All rise. Please be seated. The Special Court for Sierra Leone is sitting in an open session in the case of the prosecutor versus Charles Ganke Taylor. Justice Richard Lassick presiding.
Good morning. We'll take appearances first, please.
Good morning, Mr. President, Your Honors, honored counsel. Appearing today for the prosecution, Stephen Rapp, prosecutor, together with Principal Trial Attorney Brenda Hollis, Mohammed Bangura, Catherine Haworth, Christopher Santora, Maya Troba, and James Johnson. Thank you, Your Honor.
Thank you, Mr. Rapp. Yes, Mr. Griffiths.
Good morning, Mr. President, Your Honors, counsel opposite. For the defense today, myself, Courtney Griffiths, assisted by my learned friends Mr. Morris Anya, Mr. Terry Monyard, and Councillor Superwood, and also our case manager, Salah Moyleman. And also we're joined today by the acting principal defender, Mrs. Claire Carlton Anseals.
Thank you, Mr. Griffiths. Well, I think both parties realise there's an order permitting photography. I don't know what happened, but obviously it has not been followed. The order was in the terms that the photographer shall be in a position 10 minutes before the start of the proceedings. And I see he is not in court at all. He's entitled, once the court sits, to take photographs for a period of 1 minute. Now, I'll bring the photographer in on this occasion, but if these orders are not followed strictly in the future, then we'll simply overlook the order. Madam Court Manager. All right, thank you, Madam Court Manager. Well, today is scheduled for the opening of the defence case, and as became evident last week at the status conference, the defence will make an opening statement today. The court will then adjourn and the defence will go into evidence tomorrow morning. Having said that, I'll call on you, Mr. Griffiths.
May it please Your Honours, we've broken down our address into the following chapters. First of all, we're going to introduce the topic. We will then provide a brief chronology of how and why we come to be here. And we do that for this reason. In opening their case, we were told by Stephen Rapp, the chief prosecutor, in a speech laced with references to the geopolitics of the region, that, and I quote, "The prosecutor will seek at all times to ensure that it embodies the fundamental principles of fairness, due process, and justice, that along with the other trials at the special court will help ensure a future respect for the law and the maintenance of a just and peaceful and safe society." And in concluding his address to your honors, almost 2 years ago, in fact over 2 years ago, he said this: "There are those in this world who are ready to uphold the law and to decide that no matter how high the position of the person responsible, there will be a day of justice." Now, we say quite simply and bluntly right out at the outset that that claim is simply just not true. When one examines the way in which the Office of the Prosecution have behaved, from the unveiling of the indictment in this case and throughout the investigation and trial, we say that sentiment expressed by the prosecution at the outset is riddled with hypocrisy and untruth, and we must, if we are properly to protect Mr. Taylor's interests, address all aspects of the prosecution case, including that. Thirdly, we will then look at the reality of this supposed commitment to equality before the law by examining briefly the experience of the previous defense team. And why do we do this? Simply because Mr. Taylor may be asked in cross-examination, and we need, of course, to anticipate this. Why did you dispense with your previous defense team? We will then briefly examine when we, this team, came on board and what was our task. And in light of that analysis, we will then look at what this case is really about. What is the issue? Have the prosecution truly sought to address that issue? We are here to assist you judges, and it is important that you know what the issues are as we see them, because we appreciate that we are confined in opening our case by Rule 84, a provision of which the learned president of this court rightly reminded me last Monday. We therefore fully understand that we need to proceed with care. Now, having dealt with that, thereafter, we will necessarily have to examine the accused's decision to give evidence, because again, he might be asked about that. And in looking at that, we feel that it is equally important that we critically examine the lens through which we should examine his account. So we will examine, first of all, prejudice. We will also go on to examine emotion and the fact that neither can play a role in our task. How should the defense case be examined, we say, is a very important question. We're then going to go on and look at the prosecution case and question its adequacy. We do that because we need to define where we say it is lacking in proof, and consequently where we can assist you judges in your task by providing further proof, because we want to focus our case on just those aspects of the case. Now, having done that, we will then examine the defense case. Undoubtedly, there will be no problem with that, because at the heart of Rule 84 is what our duty is in that regard. And thereafter, finally, we will conclude. So let us commence. At the outset, we make it clear that we're not here to cause offense for the sake of it. We are here to defend a man who we say is innocent of these charges. However, whilst we appreciate that the primary function of this opening address is to outline the case for the defense in this court of law, it must equally be recognized that this case has been played out over at least 6 years by the prosecution in the court of public opinion worldwide. And so we are conscious that our audience is far wider than Your Honors, the judges in this courtroom, and inevitably we must address that wider audience, so long as, of course, we adhere to the rules. However, we bear in mind also that part of this court's ambition is to gain international respect for the rule of law, an ambition which it primarily achieves by allowing a wider world to observe and understand its habits, methods of analysis, and its findings in the cases it hears. And I've already reminded Your Honors of the lofty aspirations of the prosecution in this court. Our plea must therefore be couched in language and terms appropriate to all who have the opportunity to listen. Sadly, much of West Africa does not have that opportunity. And we are constrained to do so because we deal with reality and not theory. For we say that not many of those who readily want to pass judgment on Charles Taylor truly know the details of this case, which covers a period of history in West Africa, which for much of the time, the West and its media completely ignored. The United States of America had no time for its love child, unless, of course, it was perceived to endanger the warped Cold War logic which governed global foreign relations at the birth of this conflict. It has to be remembered that the events we are considering occurred at a time when walls were coming down. So let's move on then and deal with the chronology. Charles Taylor was indicted on the seal on the 7th of March, 2003. The indictment was announced on the 4th of June, 2003, on his first trip outside of Liberia, after the indictment had been imagined into being, we say, by David Crane, the then chief prosecutor. Now, in a revealing footnote to a prepared statement presented to a hearing before the United States House of Representatives Subcommittee on Africa on the 8th of February 2006, that same David Crane, former chief prosecutor of this court, said this, and I quote, "The unsealing of the indictment against Charles Taylor on the day he arrived in Accra, Ghana, for the peace talks in June of 2003 was a calculated move on my part." Pause there. Mr. Crane, of course, that chief prosecutor, was present at the opening of the prosecution case in this courtroom. He was afforded a name check by Stephen Rapp, the prosecutor, i.e. was bigged up in front of a worldwide audience. Yet when speaking of that piece he mentioned, it must be remembered that the statute which established this court provided that, and I quote, "This court should have the power to prosecute persons who bear, 1, the greatest responsibility for serious violations of international humanitarian law and Sierra Leonean law, committed in the territory of Sierra Leone since the 30th of November 1996, including those leaders, 2, who in committing such crimes, hear this, have threatened the establishment of and implementation of the peace process in Sierra Leone." So this is a court set up for the preservation of peace. Bearing that in mind, here we have the chief prosecutor in such a court attempting to scupper peace in Accra, Ghana in June of 2003. Why should a prosecutor in this court seek to do that? And why did he do that? Charles Taylor will explain why. But in any event, Mr. Crane continued, was a calculated move on my part to publicly strip in front of the world this warlord of his power by my signature on the indictment. Pause again. Such ego and hubris. To quote Bob Marley, my countryman, working iniquity to achieve vanity. Now let's go back to what Mr. Crane was saying. It was never intended, that indictment, to force his transfer that day to the tribunal, though we would have accepted him and were ready to arraign him on the charges within the indictment immediately. Pause again. So there we have Mr. Crane claiming that way back in June of 2003, this prosecution were ready to proceed. So we ask rhetorically, why hadn't they sorted out their indictment then? Why was their indictment thereafter edited on so many occasions, occasions of which we will remind this court? And yet look at the claim that he was making. And he continues, "My intent was to humble and humiliate him before his peers, the leaders of Africa, and to serve notice to Taylor and others that the days of impunity in Africa were over." Pause again. Why not declare the end of impunity for all international wrongdoers? Why just Africa? And then he continues, "Taylor is the first African head of state ever to be indicted for war crimes and crimes against humanity, and only the second in history. His indictment paved the way for the eventual election of Ellen Johnson Sirleaf as the first, note that, first fairly elected president of Liberia." So the Doe election of 1985, at a time when the US was pouring the greatest amount of aid it had ever had into a corrupt regime, a generosity it had never previously shown to its African slave child. And yet we are told that the election in 1997 as well, that too was obviously, given Mr. Crane's sentiment, not fair. And then he continues, "It must be noted," and listen to this, "it must be noted that the United States was given a copy of the Taylor indictment 2 months before it was unsealed in June 2003. It was personally given to Walter Kansteiner, then the Assistant Secretary of State for Africa, at a breakfast meeting in April of 2003 with the US Ambassador Peter Chavez at his home in Freetown. Another copy was given to Pierre Prosper, the Ambassador at Large for War Crimes issues as well. And pausing there, perhaps we ought to congratulate my learned friend Stephen Rapp on his nomination to soon fill that post. But he continues, does Mr. Crane, all parties were warned 24 hours in advance of the unsealing, while Taylor was in Accra. The government of Ghana was served with the indictment and the warrant of arrest the morning of the unsealing of Taylor's indictment. Now one has to ask, why was the United States of America granted this particular favor 2 months in advance? And was this court notified, given that the indictment was on the seal, that the seal had indeed been broken? Was it? Now, what I've just quoted is a mere footnote, hidden away, yet loaded with meaning, particularly when you discover that the same David Crane goes on to say this: the trick to getting a West African leader's attention is cash, plain and simple. Unlike, for example, a British Member of Parliament. And further, we say that money has played a crucial part in these proceedings, as we will deal with. Now, Charles Taylor was humiliated. That was, after all, calculated. And I can assure you that he is humbled, although only by the trust placed in him by the people of Liberia, who rallied to his banner in 1989, including one Ellen Johnson Sirleaf. And those same Liberians elected him freely and fairly in 1997, an election congratulated by a former US President, Jimmy Carter, yet ridiculed by a prosecutor of this court. However, I can assure you that he is certainly not humbled by this ill-conceived, revenge-seeking prosecution. Now, in August of 2003, he stepped down, resigned as president, and went into exile in Nigeria. How many times has that happened in Africa? Ian Smith in Rhodesia, now Zimbabwe, was certainly reluctant to do so in the face of mounting pressure, until forced by the anti-imperialist struggle to step down. Sadly, many others may have inherited his stubbornness in that country, an unwillingness to go. And let me not start on South Africa and apartheid. Yet here was Taylor going without a whimper. And he's such a bad man. And that going was done by agreement, a deal brokered by Africans for Africans, backed by the United States, the United Kingdom, and the United Nations. Yet despite that agreement, he was handed over by the Nigerians to the Liberians, and from thence to the Special Court for Sierra Leone on the 29th of March 2006. It does sound calculated, doesn't it? And 3 months later, like an illegal immigrant, refugee, or worse, and for those of an historical mind, in reverse, he was taken in chains from the shores of Africa and taken to Holland, thousands of miles away. the country of one of the colonizers of the black race for centuries. A historically familiar journey for some. So that was the challenge we faced as his defense. Now, those originally instructed to defend Charles Taylor struggled valiantly, despite an appalling lack of resources to protect his interests. This was despite the gross disparity in the resources available to the defense, particularly when compared to the largesse available to the prosecution, which even included a fund, the source of which we have been unable to identify, and out of which lavish payments have been made to witnesses. Yet despite this, that defense team struggled on until the summer of 2007, when the injustice of the situation forced Charles Taylor to withdraw his cooperation with this court. Consequently, an attempted start of this trial on the 4th of June 2007 was swiftly aborted, and we were brought on board shortly afterwards in an atmosphere of panic. This is how we come to be here. We sought and were granted 4 months to prepare, and thereafter deal with a prosecution case involving voluminous documentation, a case which they had taken years to prepare. Yet after a few months' preparation, we dealt with this case efficiently and professionally. And why? Because it's the job of the experienced advocate to quickly locate the essence of a case and thereafter seek, for the sake of efficiency and brevity, to conclude it as swiftly as possible. That we have always sought to do, so that this case proceeded from the 7th of January 2008 to the 27th of February 2009 without hardly a hitch or delay. Unprecedented in my experience of almost 30 years for a trial of this complexity and logistical difficulty. This was 91 witnesses and 14 months later. And why was that? That was because we defined the issue here as being simple. We stated it at an early stage, and it remains our position. Consequently, it is not surprising that the prosecution themselves observed in opening this case, and I quote, the quote was to the effect that the essence of their indictment was how to link Mr. Taylor to these crimes. And consequently, we said this case should not have been about what in fact happened in Sierra Leone. There was no issue about that. It should solely have been about who bore the greatest responsibility. There being ample proof that he had made, that is Mr. Taylor, strenuous efforts to achieve peace in Sierra Leone, remembering, of course, the words of the statute. Proof which we will provide in abundant documentary form. Proof available to the prosecution, but which they ignored. We consequently do not, and never have, taken issue with the fact that terrible things, atrocities, were committed in Sierra Leone. We've never done that. We still cannot therefore understand why more than half of the witnesses called were so-called crime-based witnesses to prove a fact not in dispute. Let me assist with one or two statistics. 91 prosecution witnesses were called. Of those, 52 were so-called crime-based witnesses. 33 were so-called linkage witnesses. But also appreciate this. The case having begun in January of 2008, by September of the same year, so 9 months later, 27 of the 33 linkage witnesses had been called by September. So effectively, by September of last year, the prosecution had called the vast bulk of the evidence available to them on the central issue in dispute. And yet we spent from September right through until February of this year listening to some 42 crime-based witnesses giving evidence about the horror of their experience, a matter not in dispute.
Yes,
I'm
Mr.
reticent to rise, but the purpose of an opening statement is to talk about the evidence that the defense intends to present. They're talking about evidence that the prosecution presented, numbers. I think the record reflects that all but 2 of these crime-based witnesses the defense objected to presenting in written form, and we're hearing more argument at this stage that's probably fit for closing rather than for telling us what kind of evidence we're going to receive from the defense.
Yes, Mr. Griffiths.
Where I come from, Mr. President, it's regarded as rude to interrupt opposing counsel's opening speech or closing address. It's normal, in my experience, for such comments to be reserved until the address has been concluded. But in any event, we say, given the latitude afforded to Mr. Rapp when he was opening the prosecution case, we submit that we're perfectly entitled to make the points that we do. Particularly as we do so, we say, in order to set out the issues which we set out from the outset, which we feel we have to address, we cannot just go into a recitation of the defense evidence without any kind of context.
Well, firstly, I can tell you, Mr. Griffiths, that when the prosecution made its opening statement, the court took care to confine the prosecution as much as possible to the evidence it tended to present. And as you've already made comment, you're well aware of the requirements of Rule 84. But we seem to, I beg your pardon, we're of the view that what you're saying now is tied in with evidence that you're going to present anyway. And we think that you're doing your best to lay out the defense case. So we're going to overrule the objection, but we will direct your mind now to what Rule 84 requires of you.
Very well, Mr. President. In any event, Your Honors, having defined the issue as we did, we resolve not to be distracted from the central question. That question being, how do you, the prosecution, say he is responsible? Yet we say, still, more than 6 years after the Office of the Prosecution first formulated the indictment, it remains uncertain where it should be precise. Thus, all of the following are suggested by the prosecution. Article 6.1 of the court statute explicitly lists 5 ways in which Charles Taylor could be held responsible for the atrocities that took place in Sierra Leone. That article holds individually criminally responsible or accountable persons who planned, instigated, ordered, committed, or aided and abetted in the planning, preparation, or execution of a crime within the court's jurisdiction. In addition, there is a 6th truth by which they claim he is liable. That 6th way in which Mr. Taylor could be held criminally responsible by this court is pursuant to Article 6.3 of its statute, but only to the extent that somebody, that he, Mr. Taylor, exercised authority over as a superior, someone who committed a crime within the court's jurisdiction, and that he knew or had reason to know that his subordinate was about to commit such acts or had done so, and he, Taylor, failed to take necessary and reasonable measures to prevent such acts or to punish the perpetrators thereof. Now, the final route, the final way in which Charles Taylor could be held individually responsible is under a theory of joint criminal enterprise, or JCE. Something which those of you who have been following this case know has attained infamous status because of how tortured its various formulations have been since the first indictment in March 2003. With this supposed route to conviction, there have been so many different formulations of it during the course of this case that it's, frankly speaking, difficult for one to keep track of what case Mr. Taylor is supposed to answer. Let us just trace that development. Stage 1. In the first indictment that was signed by David Crane, it was alleged that Mr. Taylor participated in the joint criminal enterprise as, quote, part of his continuing efforts to gain access to the mineral wealth of Sierra Leone and to destabilize the government of Sierra Leone. Stage 2. When prosecutor Desmond De Silva filed the amended indictment on the 7th of March 2006, the phrase joint criminal enterprise was nowhere to be found in the indictment. Indeed, it had been deleted from the indictment in its entirety. Phase 3. Over a year later, on the 4th of April 2007, a couple of months before the trial was due to start, and after several years of preparation, when the prosecution filed its pre-trial brief in this case, we began to see the emergence of diamonds as an expressly stated reason for Mr. Taylor's alleged participation in the common plan of the JCE. The pre-trial brief alleged that Mr. Taylor, quote, participated in a common plan, design or purpose to gain and maintain political power and physical control over the territory of Sierra Leone, in particular the diamond mining areas, in order to exploit the natural resources of the country. They went on to add, quote, implementation of this common plan included overthrowing the government of Sierra Leone. Stage 4. A few weeks later, during my learned friend Mr. Rapp's opening statement on the 4th of June 2007, he said that Mr. Taylor was, quote, responsible for the development and execution of a plan to take political and physical control of Sierra Leone in order to exploit its abundant natural resources and to establish a friendly or subordinate government there to facilitate that exploitation. However, stage 5. When you judges in this chamber rendered your judgment on the 20th of June 2007 in the AFRC case and ruled that an alleged common purpose to take any actions necessary to gain and exercise political power and control over the territory of Sierra Leone, in particular the diamond mining areas, was not an international crime, nor a crime punishable under statute. The prosecution panicked and filed on the 3rd of August 2007, version 5, an amended case summary, alleging there that the common plan that was shared by Mr. Taylor and other participants in the JCE was to inflict a campaign of terror on the citizens of Sierra Leone in order to pillage the resources of Sierra Leone, in particular the diamonds, and to forcibly control the population and territory of Sierra Leone. Yes, it had become terrorism. Now, I wonder where that term terrorism came from at a time when the so-called war on terror is still ongoing. A war which has dominated our lives for over a decade. So we say now that we've reached July 2009, which is it? Diamonds? Or is it political control? Or is it overthrowing the government of Sierra Leone? Or is it terrorizing the citizens of Sierra Leone? Which is it? Why are we, several years down the line, faced with this lucky dip of a prosecution as a supposed pathway to proof? We say the indictment is still unclear, 6 years after it was first unveiled. What kind of a prosecution, we say, is this? Take your choice, because we're not sure. And this is the party to these proceedings which bears the burden of proving guilt beyond a reasonable doubt. And they themselves clearly, by the history of their behavior, are not sure. We say, had Mr. Crane all those years ago concentrated more time on doing his job as a lawyer and less as a politician, had he concentrated on his job as a lawyer rather than seeking to humiliate and humble an African, then maybe we would have a clearer idea today as to why we are here. So moving on, the decision to give evidence. Since he was taken to Freetown, Mr. Taylor has not said a word in his own defense. He has kept his own counsel. This is his first and perhaps only chance to give his account. Now he takes the opportunity to put forward his defense. Not because in law he has to, but because he wants to. He feels it's important to set the historical record straight. Nevertheless, before he sets out his case, he appreciates that he faces some important hurdles. So let us address them directly right at the outset. The first, we acknowledge. Yes, the first is the deeply ingrained popular prejudice against Mr. Taylor, held by so many who have not listened or observed the full and dreadful story of what happened in West Africa from 1989 to 2003 and what had led to it. A decade and a half period of bitter tears, still bleeding wounds, destruction and death, images of trauma, human suffering and inhumanity, more easily erased from the memory than remembered because of their sheer brutality. All of this happening in the neighboring countries of Sierra Leone, Cote d'Ivoire, and Liberia, a part of the world blessed in so many ways and endowed with such great beauty. Yes, I'm talking about that prejudice, based, we say, on lies, based on unsubstantiated rumor, and hearsay without independent support. That public opinion which has already given its outspoken verdict and condemned Charles Taylor. Yes, I'm talking about that prejudice which nullifies objectivity, neutralizes independence of thought, and thereby corrupts justice. Surely we're all here for more than that. Surely we are here for more than humiliation at the stroke of a pen, which says more about the humanity of the speaker than the justice of the cause. Because none of us should be here to speculate. No, we're not here to do that. Neither are we here to make intelligent guesses. No, we're not here to pursue theories. For example, that Taylor was a despot, Africa's Napoleon, bent on taking over the sub-region. We're certainly not here to act on suspicions, hunches, or sixth senses, or indeed on hearsay alone. We do live our lives on instincts, but we're not here to exercise instincts, to motor on automatic, because here in a criminal court, things slow down. Because here what is required is proof, the application of logic, and intellectual honesty, so that when each of us arrive at our individual verdicts, we can say, hand on heart, that those verdicts were not influenced by prejudice, a previously held view unchanged by the evidence. Because the definition of a fair trial has been handed down to us after centuries of struggle. And it is a definition to which we should hold fast in a court of law. Guilt must be punished without prejudice. And where there is no guilt, then once again, prejudice must not be allowed to rear its head. This being so, before we come to deal with the charges themselves, we have certain requests to make of everyone listening. We're addressing our audience now. Firstly, that everyone approaches the case without preconceived opinions, since nothing else would be fair. For if we, coming to observe a tribunal of this kind, insist on basing our judgments upon conclusions that we have previously formed ready-made, instead of deciding in accordance with the facts, then none of us would have the right to say that we have fairly stood in judgment. Frankly, your reputation as judges would be gone. However, let us suppose that you have formed a preconceived opinion all the same. Then in that case, what we demand is this. If you find that our reasoning uproots that opinion, if our argument undermines it, if truth destroys it, please, we say, do not resist, but rather dismiss those preconceived ideas from your mind and seek to arrive at a verdict in light of the facts you find proved, drawing proper and reasoned conclusions from the evidence. Because to do otherwise, frankly, merely strengthens the very mischief we're all seeking to prevent. We also need to beware of emotion, because emotion is no useful guide to us in our task. We must be dispassionate, carefully analytical, and objective in our assessment of that evidence. No one who has seen the sad procession through this courtroom of hurt human beings, reliving the most grotesque trauma, would have been unmoved. We are human too, even whilst we declare this accused man to be not guilty of the charges he faces. We are humans too. 52 out of 91 prosecution witnesses called were crime-based witnesses. All these witnesses later, images of unspeakable humoring suffering later, must have an effect. And we appreciate that it may well skew rational and logical thought and thereby erode any notion of justice. We must therefore consciously guard against this in deciding whether any material fact has been proved beyond a reasonable doubt. Moving on. In opening the prosecution case, we were told that this case involved one overarching crime, the crime of terrorism. Thus they planned to terrorize the civilian populations of West Africa. But as I've already indicated, they also intended to take political and physical control of Sierra Leone in order to exploit its abundant natural resources and to establish a friendly or subordinate government there to facilitate that exploitation. Yet it's the indictment which should provide the roadmap to guilt. As with all maps, we expect them to be drafted with precision and that they can be trusted. Otherwise, we could get lost. Now, the first indictment against Charles Taylor was signed by David Crane on the 3rd of March 2003 and filed with this court on the 7th of March of that year. An amended indictment was signed on the 16th of March 2006 by Sir Desmond De Silva, as he now is, and filed with the court on the 17th of March. That was the second indictment against Charles Taylor, and it had annexed to it something called a case summary. Case summary accompanying the amended indictment, a document which purported to elaborate further on the bare bones, as it were, of the amended indictment. Less than 1 week before the 4th of June, when the trial against Mr. Taylor was expected to start, the current chief prosecutor, Mr. Stephen Rapp, signed what would be the third indictment to be issued in this case against Mr. Taylor, with the filing on the 29th of May 2007 of the prosecution's second amended indictment. Again, and much like with the amended indictment that Prosecutor De Silva had filed, a document called a case summary accompanying the second amended indictment was filed by the prosecution on the 3rd of August 2007, purporting to elaborate on the charges that were contained in the 29th of May second amended indictment. Let us now examine, for the purposes of our case, the detail of that indictment. One or two salient facts immediately become clear. The first is this: the vast bulk of the charges relate to 3 provinces in eastern Sierra Leone: Kono, Kailahu, and Kenema. Other provinces are implicated, but in terms of the timeline, only briefly. Now, turning to that timeline, bearing in mind, of course, the terms of the statute which set up this court, and starting from the outer limits and working in, the plan to which Mr. Taylor is said to be party was supposedly hatched in Libya in the 1980s. It was put into effect when he invaded Liberia on Christmas Eve 1989. So at one end, that's the outer limit. We know at the other end, August 2003 steps down and goes into exile. Let's just bring the boundaries in a little further now. We know that thereafter the indictment period dates from the Abidjan Peace Accord, 30th of November 1996, through to President Kaba declaring peace in January 2002. But even within those parameters, the real core of this indictment effectively dates from February 1998 to the end of January 1999. A period when, as the prosecution rightly stated in their opening, the violence in Sierra Leone reached a crescendo. So in effect, what we're here dealing with is roughly a 12-month period from February 1998 through to the end of January 1999. Why those parameters? February 1998 is the ECOMOG intervention, when we say a group of Sierra Leonean soldiers who had formed the junta regime, the AFRC regime, felt disgruntled, downright annoyed and angry that a force of Nigerians, without any sanction from the United Nations or anybody else, kicked them out of power in Freetown. And thereafter, history shows that those same disgruntled soldiers went on a campaign, an orgy of violence, which took them to the north of Sierra Leone, returning back to the Western District late in the year of 1998, and thereafter, on the 6th of January 1999, wreaked havoc and destruction in Freetown. That is what is at the core of this case. And that is what we shouldn't lose sight of. Yes, there are counts which extend beyond that time frame, but that period is really at the heart of this prosecution, and that's what we ought to concentrate on. Now, having examined that, let us remind ourselves also that although the indictment itself is set in narrow limits in terms of time and territory, here November 1996 to January 2002, solely limited to Sierra Leone, the evidence nonetheless placed before this court and relied on traverses a much wider historical and geographical period. Thus, in terms of this timeline, we were told that the plan at the heart of this design, quote, was formulated in Libya by the accused. That's a long time outside the indictment period. Further, in geographical terms, much evidence is being called of events in Liberia from the likes of Hassan Bility and TFI 590, none of which on the face of it seem to have much to do with the issue at hand, rather than a search for prejudicial evidence. So the narrow limits set by the statute have been exceeded considerably. This expansion, whilst not accepted, has to be addressed. Consequently, the defense case cannot be dealt with within a narrow compass. So let me then turn now to the defense case. Now, the accused does take issue with the prosecution allegation that he, by reason of any of the modes of liability alleged in the indictment, was responsible for any of the crimes charged. He says simply, I am not guilty of these crimes. In a sentence, he says, how could I have been micromanaging a conflict in neighboring Sierra Leone, as alleged, when I, as newly elected president of the Republic of Liberia, had so much on my plate to deal with? Bearing in mind the core of the indictment is conveniently situated during the period of his presidency. And he's saying, how could I have been micromanaging all of these radio operators, these bodyguards, these low-level individuals who claim to have been in direct contact with Mr. Taylor, when I'm running a country besieged on several sides, firstly by Ulimo, then Lurd, then Model? How could I? Now, in giving evidence in his defense, it must be borne in mind at all times that he bears no obligation to prove his innocence. His protection is that it's for the prosecution to prove his guilt. That is because criminal trials have come, at least in those societies committed to the rule of law, to be governed by a certain logic. It is a logic the long time in the making, very painful in the making, in terms of suffering, in the achievement of it. However, with that principle firmly in mind, it is anticipated that Mr. Taylor's testimony will cover the following areas. Firstly, he's going to deal with his personal background, including, among other things, his background, history, and education. And why is that necessary? It's because it feeds in his origins, that is, into the ethnic politics of Liberia and the historical tension between the Congo town set, the American Liberians, that is, and the rest of the indigenous population. A conflict which has been at the heart of Liberian politics for well over a century. So that's why we're looking at the background. Because frankly, that background is a history of racism, constructed elsewhere, but transferred to Africa. And here we will, of necessity, have to pause to consider the relationship between the United States of America and its prodigal child in Africa. Having dealt with that, we will go on to consider his involvement in ULA, the Union of Liberian Associations in America, an association which began whilst he was studying in the United States of America. Having dealt with that, we will deal with his involvement with the government of Samuel Doe, and also his increasing disenchantment with the Doe regime. Having done that, we will look at the Quiwamka attempted coup and its aftermath, so brutally predictable, as Doe, of the minority Kran ethnic group, mobilized his largely Kran army under the command of a fellow Kran, the notoriously inhuman General Charles Julu, who, after murdering and mutilating Quiwamka, who was captured after the abortive coup, the ex-general's decapitated body was displayed in a public square in Monrovia. After that, Julu was unleashed to pacify Nimba County, ancestral home of Quiwamka. Julu's army carried out brutalities unprecedented in even those violent Liberia, killing thousands of defenseless peasants, destroying homes, pillaging businesses and farms, and raping women. Thousands fled in terror and horror to neighboring Côte d'Ivoire. And memories of those atrocities were still fresh in the minds of Nimba residents, when on Christmas Eve of 1989, some 100 special forces of the MPFL, armed with a couple of hunting rifles purchased in the Côte d'Ivoire, entered the town of Butu in Nimba County. They were mostly drawn from the Geo and Mano ethnic groups of Nimba County that were persecuted under Doe's regime. They made rapid progress. The choice of Nimba County as the launch pad was deliberate and strategic, as the NPFL ranks swelled overnight with willing and adventurous recruits, many undoubtedly seeking revenge for the depredations of the Doe regime. Further, scores of dissidents who had gathered and congregated outside of Liberia also flocked to the banner of the NPFL, united in one cause: the elimination of Doe and his ethnic Crown and Mandingo supporters, and the seizure of power. Bluntly, it was about taking power. Now, Mr. Taylor will also deal with his arrest by the United States authorities at the request of the Doe government. That too has to be a part of the overall picture. Otherwise, we may fail to understand the real issues and the real forces at work behind the scene. However, when saying that, much of what we say about the background to these events is a matter of historical record. And in the circumstances, we see no need to burden this tribunal at this stage with further details. However, Mr. Taylor will go on to detail the history of the formation of the NPFL, carrying on a tradition in the name of the glorious attempt by Kpakio. Mr. Taylor didn't invent the name NPFL. That was Kpakio. So he was merely taking up a banner which had been so brutally crushed by Doe. Now he will deal with the motivation behind the organization of the NPFL and its philosophy. He will accept that his forces were trained in Libya. He will accept that. And that they were indeed special forces. And he will remind us that this training took place during a period of Pan-Africanist movement and struggle. And he will also explain the need to see that development against the background of a Cold War nearing its end, in the face of the collapse of the Soviet Union and the construction of a world with just one superpower, the United States, and its important ally, the United Kingdom, which had a stake, remind us ourselves, in Sierra Leone, and which also, the same United Kingdom, feared the emergence of Nigeria as a regional superpower. And Mr. Taylor will remind us that there were groups at that camp in Libya from all over Africa and the rest of the world. He will tell us about that. And he will tell us, in terms of that period, that he was in contact with a group of Sierra Leoneans. This is in Libya, amongst others. But the Sierra Leoneans, that group he was in contact with in Libya, they were called the Sierra Leonean African Revolutionary Movement. Pan-African Revolutionary Movement. Let me say that again. The Sierra Leonean Pan-African Revolutionary Movement. They were not called the RUF. And he will also tell us that one Ali Kaba, a former student dissident from Freetown, and also a relative of Tejan Kaba, the former president of Sierra Leone, that it was that Ali Kaba who was in charge of the Sierra Leoneans in Libya. However, he will refute the suggestion that he combined with either Ali Kaba or others in Libya to pursue a design to terrorize the civilian population of Sierra Leone. He will totally refute and reject that. He will assert that such a suggestion is completely contrary to the revolutionary and liberating ideology which informed the actions of those who trained in Libya, and the spirit of comradeship which infused their actions thereafter. He will point to the hypocrisy of the prosecution on this point. Whereas they accept, and again I quote Mr. Rapp from his opening, by the early 1990s, Sierra Leonean citizens had grievances against the government in place. That is accepted. Yet nonetheless, the same prosecutions seek to illegitimate and demean their attempt to do something about their condition by labeling them terrorists. Thus the prosecutions say, quote, some say the RUF was fighting in Sierra Leone for a kind of national liberation, for the betterment of the people of that country. But we submit that there was really only a thin veneer of ideology that masked the real motive of destruction and exploitation. In other words, they were from the outset merely a bunch of bandits, thieves, murderers, and rapists. That's all they were. That's the suggestion. Now, the accused will also further deal with his relationship with President Momo of Sierra Leone and his presence in that country in the late 1980s. Thereafter, he will recount the launch of the Liberian Revolution from the neighboring territory of the Côte d'Ivoire. He will detail how, despite the fact that at the outset of the revolution, he could call upon less than 200 trained special forces, he could quickly call upon tens of thousands of ordinary Liberians. Ordinary Liberians motivated by their detestation of the cruelty and carnage of the Doe regime, and how, with that force, they quickly routed Doe's army. He will go on to describe how the phenomenon, that dreadful phenomenon of child soldiers, had existed in this part of Africa, and indeed elsewhere, and had been a feature in many instances of civil war and armed insurrections around the world, well before Charles Taylor emerged on the scene, as the prosecution's own expert, Stephen Ellis, was forced to concede. child soldiers were not a Charles Taylor invention. Let me repeat. Child soldiers were not a Charles Taylor invention. The RUF did not need to look to him and his NPFL for a role model, although it is accepted that the brutality of the Doe's regime's soldiers and supporters, particularly in Nimba County, had given it a terrible impetus, with many children left as orphans, with no refuge except within the ranks of the NPFL. But those children, he will tell you, were used in various roles other than combat. Now, in recounting this history, he will further describe the attempts, fraught with practical difficulties, made to impose discipline within the ranks of the NPFL. Having dealt with that, he will explain his relations with the RUF, his knowledge or lack thereof of its creation. He will further describe the unplanned nature of the spillage of conflict from Liberia to Sierra Leone, a consequence in large measure of the historically known links between the two societies and the porous border between the two countries, a fact accepted by the prosecution when in opening they said Sierra Leone is located in a region where borders exist only on paper. These lines were drawn in the colonial period and do not follow ethnic or linguistic groupings. Many in upcountry border areas have closer relations to people across the border than to those in their own capital cities, which can be said with force, particularly about Kailahun and that part of eastern Sierra Leone. And he will question, in looking at that history, whether such a peaceful people as the Sierra Leoneans undoubtedly are, whether they are in denial of their own clearly recognized hand in the carnage visited upon themselves, and thus are forced to look to another to bear the guilt. Now, the accused will deny the allegation that he controlled the RUF. He will further deny any formal association with Foday Sankoh, or the suggestion that he was party to a joint criminal enterprise with Foday Sankoh, which dated from the 1980s in Libya. In particular, the accused will refute the suggestion that as leader of the NPFL, and later as president of Liberia, he was involved in any formal supply of arms and ammunition or other war materiel to the RUF or the AFRC. He will assert that this was never the official policy of the NPFL or the Liberian government whilst he was president. He will also explain the situation surrounding arms and ammunition supply in Liberia at that time, and the impossibility for him to provide such material as suggested by the prosecution. The accused will also describe the intervention of ECOWAS in the Liberian conflict through the deployment of ECOMOG. He will explain that the contributing countries to that ECOMOG force were pursuing a policy aimed at denying the NPFL the fruits of their success in mobilizing the Liberian populace against tyranny. He will outline the hypocrisy of some of those contributing countries who, whilst proclaiming that they were in Liberia to promote peace, nonetheless funded and assisted first the LUDF and ULIMO to launch an illegal war against the NPFL and by extension the Liberian people, and thereby extend by several years the suffering of that same Liberian people. Life on the NPFL ruling Greater Liberia will be described. The repeated attempts to promote peace and disarmament in Liberia will be outlined, and the efforts of the accused to bring about that happy outcome. The process of disarmament in Liberia will be explained, and the successful transition to democratic elections in a war-ravaged country. This aspect of his evidence is directly relevant to the erroneous suggestion that he was in a position to provide arms to the RUF. The general elections of July 1997 will be described, along with the resounding victory achieved by the accused in elections internationally observed to be free and fair, yet derided by this prosecution. The accused will go on to describe the challenges of governing a post-Civil War society, historically divided, as he will explain, between Congo town and indigenous, historically driven by factionalism, and how he was having to contend with that whilst denied access to foreign inward investment to rebuild a ravaged infrastructure. He will explain how he repeatedly sought to secure the Liberian-Sierra Leonean border to confirm his continued assertion that the Liberian government were not assisting the RUF, and further to contain the contagion of war and thereby permit his efforts to rebuild the Liberian economy. We have ample United Nations documentation to support that. He will also testify on the safekeeping and destruction of all arms, ammunition and artillery handed in during disarmament in 1997, before the general election, destroyed by the United Nations with the approval of his government. We say that in the case of Charles Taylor, here we have a leader kept fully occupied by Liberia's national affairs, seeking to repair the past and at the same time anticipating the possible demands of the future, the arrangements by which peace had to be established, the powers needed to defend the Republic. These are the matters to which he devoted himself and over which he exercised a degree of control. Matters of the utmost importance for his country engrossed his continual attention, so that he scarcely had time to breathe. In these circumstances, it is surely not very surprising if, from time to time, there was something or another which escaped his notice. He will point out the obvious historical fact that the AFRC coup in Sierra Leone predated his coming to power as president of Liberia. He was engaged in a general election at the time, with the concomitant conclusion that he played no part in the ousting of the Kaba government. There has been no evidence called to suggest that he played any part whatsoever in the AFRC coup in May of 1997. None whatsoever, not a shred of it. Furthermore, it must be borne in mind that those who seized power so illegally in Sierra Leone had no historical link whatsoever with Charles Taylor. He will testify and deny any suggestion that he provided the AFRC with any arms and ammunition, although he will accept that overtures were made to him when he became president by the junta regime. He will accept that. But he will say that he rebuffed those overtures in accordance with ECOWAS policy to which he was a party. He will go on to outline Liberia's appointment to the Committee of Five after he became president, and his own personal commitment to the overriding objective of that body, namely to bring peace to the sub-region as mandated by ECOWAS. He will point out that it was in late 1997 that Liberia was made a member of the Committee of Five on Sierra Leone and placed on the front line by his colleagues in ECOWAS to get personally involved in helping to bring peace to Sierra Leone. And again, we will provide ample written evidence from other members of the Committee of Five showing that he was personally requested to play that role. And his selection for the role should be obvious. Why not let a former rebel deal with rebels? And after all, they do share a common border. So he will testify about his involvement in dealing with the many ceasefire agreements between February 1998 to 2000. He will deal with the breakdown of those agreements and his efforts to put things back together again in order to ensure the continuation of peace. He will deal with his part in the Lome Agreement, the progress towards that agreement, efforts to destabilize that agreement, and consequently his involvement in the West Side Okra Hill situation, his involvement with the removal of Johnny Paul Koroma from Sierra Leone to Liberia to preserve peace, the moving of Sanko and Johnny Paul Koroma from Liberia to Sierra Leone, a fact fully documented in United Nations records, which show that it was at the behest of others that he became involved in that process. It will also deal with the extraction of Sam Bokkary in December 1999 from Sierra Leone to Liberia. Again, a fact fully documented in United Nations records. That was done not because, as suggested, of some long-standing relationship between Taylor and Bokkary, but rather in an effort to preserve peace, which Bokkary was threatening. And we have the records to prove it. He will also deal with the appointment of Issa Sisse as the leader of the RUF. Again, not because he was the man in control of the RUF, but because a collective decision was taken at ECOWAS level that because of the situation of Sanko, they needed someone to deal with within the RUF. And he was the one deputed to bring that about. And yet now, everything is turned on its head. And that is now used against him as evidence of his control, when he was merely acting in accordance with United Nations policy, which those people on the other side of this room know about. And had they had the diligence to find the documentation and place it before this court, we would not have been proceeding on a misconception these past few months. So he will deal with that. And he will deal with the subsequent final piece in Sierra Leone, all of which were done with the knowledge, consent, and participation of ECOWAS and the United Nations. There is ample documentary proof of it. And he will say that these activities in which he engaged was in fact carried out on behalf of ECOWAS, and at no stage was he acting in an individual capacity as president of Liberia. Goodwill on his part, he will say, has been turned on its head in a desperate, vain attempt to find proof. He will also vehemently deny the suggestion that he played any part in the orgy of violence which followed the ECOMOG intervention in Freetown in February 1998, and which led to the removal of the AFRC regime. In like terms, he will deny any involvement in the carnage and brutality popularly described as the Freetown invasion of the 6th of January 1999. He will point to the clear historical record which makes clear who were the real perpetrators of that particular atrocity. Yet, as I indicated earlier, the vast bulk of the indictment is concerned with that core period in the history of Sierra Leone. The period when, to quote, the campaign of terror against civilians not combatants reached its peak. That is the period which needs to be examined with care. It falls squarely within the indictment period. In this regard, we will ask this court to note the shadowy role of certain foreign powers whose pursuit of their own selfish interests in the region led to the continuation of the war in both Liberia and Sierra Leone. He will point in particular to the role played by such mercenary groups as Executive Outcomes and Sandline, and the hypocrisy of the international community in denying Charles Taylor the wherewithal to protect his people against the depredations of foreign-financed and supported militias, while failing to condemn the actions of others, like the United Kingdom government, who acted in clear breach of United Nations injunctions. By way of example, he will show how the first attacks of Lurd followed shortly after the destruction by the Liberian government of arms and ammunition handed in during the ceasefire in Liberia. We say it was not just a coincidence. He will also explain that despite these domestic pressures, his colleagues on the Committee of Five still sought his involvement in the Sierra Leonean crisis and implored him to bring the parties together to achieve a lasting peace. Remember the words of the statute, we say, threaten the establishment of and implementation of the peace process in Sierra Leone. So yes, he will be explaining how these same colleagues, aided and abetted by the United Nations Secretary General and others, prevailed upon him from 1997 to 2001 to play a frontline role in the conflict as a broker for peace. He will describe in detail his efforts to defend a fledgling democracy in Liberia from the predations of foreign-supported factions. Let us ask ourselves, who supported LERD and funded them? Who supported, funded, and organized Model? Groups bent on overthrowing his government and promoting war and dissension in Liberia. It's called regime change. That's what it's called. We don't like you, so we will get rid of you. It is called regime change. And he will go on to explain how he sought to promote peace in the region, particularly to bring an end to the conflict in Sierra Leone and Ivory Coast, whilst at the same time struggling to defend his country from that foreign-inspired assault. Whilst facing continued efforts to destabilize Liberia, he will explain the prominent, continuing, crucial, and well-documented role he played in bringing about a successful agreement to the peace talks in Lomé. Now he may, if it's deemed necessary, explain the efforts made by the Liberian government to obtain the materials necessary to defend his country. He may do that, if it's thought to be necessary. But in doing so, he will assert the unchallengeable right of a people to defend itself. It's called self-defense, and it's no offense. And he will also explain his relationship with Sam Bokary and his efforts to achieve the removal of Bokary to Liberia at the behest of ECOWAS and the United Nations in order to preserve the promise of Lomé. In the same vein, he will describe the positive role he played in securing the release of the United Nations peacekeepers, and the fact that throughout that episode, he acted with the full backing, oversight, and support of the United Nations. He will finally describe the end game, the final destruction of this democracy in Liberia by foreign-supported factions. He will describe his efforts to bring an end to the suffering of the Liberian people. He will describe the clear, and you may feel, shocking attempt by David Crane, chief prosecutor of the Special Court, to scupper the peace talks in Accra in March 2003 by timing the unveiling of the indictment against him to coincide with those efforts. Remember the words of the statute. We say that was the case of a supposed minister of justice seeking to scupper attempts at peace. Precisely what this court is supposed to be about, and thus the saving of life. He will describe how he magnanimously agreed to take the unprecedented step of standing down as democratically elected president of Liberia in order to spare his people continued suffering from yet more civil war against his democratically elected, let us not forget, government. And he will describe how the agreement which led to that momentous decision, him standing down, was backed by the United States, the United Kingdom, the United Nations, and several African leaders. And how that agreement was betrayed, and he was handed over, contrary to the agreement, to this court for trial. How many in Africa step down peacefully and hand over power? Power, yes, that addictive thing, so peacefully. How many do that? And let us remind ourselves that it's not just black Africans who have refused to hand over power in the face of the greatest obstacles. The most embedded examples are of white men refusing to hand over. Ian Smith in Rhodesia and that vile apartheid regime in South Africa. Those are the best examples. And we will seek to expose the corruption at the heart of this prosecution, how evidence has been bought and been secured through favors. Many may have become bored with our efforts to expose this aspect of the prosecution case, but we have persisted because justice cannot be polluted in this way in our eyes. It is much too precious for that. Mr. Taylor will bluntly declare that his trial is political, and he will point, among other things, to the failure to indict former President Tejan Kaba, despite his role as defense minister in the Sierra Leonean government throughout the formation and deployment of the CDF, or even though he must, the same President Kaba, on any objective analysis of the phrase, persons bearing the greatest responsibility, he must have been a more appropriate candidate for indictment than Hinga Norman, the deputy, remember, defense minister. So we ask, why was Kaba spared and not Taylor? Why? And we also point to, in that regard, the statements of David Crane at various times during his tenure of the role of chief prosecutor, and others who have followed him in that role. Those are all important matters. But we ask you to underline this concern. Why so many years after this indictment was unveiled are we still faced with this lucky dip? Why? Pick your choice kind of a prosecution. Now, in concluding, we know that what we have to say during our case may take some time. We acknowledge that things may not always run smoothly during the currency of our case, because frankly we are still preparing it. But nonetheless, experience should teach us that truth is often to be found only through a slow and painful process. That same experience should teach. It should teach us that it's better that we take time to achieve a fair verdict than rush to judgment, because then we may have to deal with the human pain of a miscarriage of justice. And undoing that kind of pain takes time. So rather, let us give ourselves the time to do justice first time round. Those are my submissions, Your Honours.
Well, thank you, Mr. Griffiths. Are there any other matters before we adjourn? All right. Well, the defence is.
I'm sorry.
I was asking Mr. Griffiths if there are any other matters before we adjourn.
Well, I think Mr. Taylor was giving me some instructions on that. I wonder if I could have a moment.
Certainly.
There is a matter, Your Honours, which Mr. Taylor would like me to raise with you at this moment. Bearing in mind that his testimony is likely to last for several weeks, and the obvious strain and pressure that that must place upon an individual who is giving testimony in a case of this gravity, the application is that during the giving of his evidence, we sit a 4-day week, but not on Fridays, in order to give him an opportunity of, frankly, recharging his batteries, because of the length of time he will be giving evidence. And we consider in the circumstances, whereas we are anxious to conclude this trial and indeed his testimony as soon as possible, Your Honours might consider that in these unique circumstances, it may be a reasonable application that we're making. It's only for his evidence, not for the rest of the defence case.
That's appreciated. That's a matter that we'll decide and deliver our decision tomorrow morning. But before we adjourn, did you have any views on that, Mr. Rapp?
Well, Your Honours, we have this courtroom exclusively through December as far as the ICC is concerned, and I don't want us to lose any of the time that we have available here. And other witnesses, some have been on the stand for more than a week, some for more than 2, and they testified on Friday, and it's only a part day, and it's only a 5.5-hour day. So we respectfully ask that we use the time that's available to us to proceed with this case.
Thank you. Well, Mr. Griffiths, was anything said there that you wanted to reply to? All right, thank you. Well, the defence is due to call evidence tomorrow morning. This court is adjourned until 9:30 tomorrow.
All rise.
All right. Let me see. Good morning. Good afternoon to all of you. Let me just go into some of the detail here. The lawyer you see here right now, his name is Courtney Griffiths. He's a British qualified lawyer. He was actually hired by Mr. Charles Taylor himself after he sacked the first batch of his lawyers, those that were pleading for him. He sacked them due to some other problem he thought, they were not handling very well. So Griffiths, QC Griffiths replaced him. So in this particular, what you just coming from hearing is his opening statement when he took over officially as the lawyer for Mr. Taylor, and leading his ground rules and ground of that he will be hitting on later on in the case. The prosecuting lawyers, let me just show you them. The prosecuting lawyers are, let me see, this is one on the prosecuting bench. Brenda Hollis is the lead. Where is Brenda Hollis? Brenda Hollis should be somewhere in front here. Yeah. Okay, this is Brenda Hollis. She's the lead prosecuting lawyer on this particular case. So the whole team that you saw behind her, that's her team there, and the team you saw behind QC Griffiths, also his team there. So the next we are going to go now, because the lawyer Griffiths finished opening the argument. So the next version of the trial is when he himself will start cross-examining Mr. Taylor. So every question that will be coming out hitting at Mr. Taylor will be directly from his own lawyer. So I hope you won't come back to ask me again. So we will go into that right now. Thank you so much for watching. Let me see. I think I need to do something first. Don't go away. Just stick and stay with me. Let me see whether I can get this. And then okay. So okay. I thought you were going to be a little while. So the main case now, I'm going to start.
Please be seated. The Special Court for Sierra Leone is sitting in an open session in the case of the prosecutor versus Charles Ganke Taylor. Justice Richard Lassick presiding.
Good morning. We'll take appearances first, please.
Appearing this morning for the prosecution, the prosecutor, Stephen Rapp, Mohammed A. Bangura, Christopher Santora, Maya Dimitrova, and myself, Brenda J. Hollis.
Yes, Mr.
Good morning, Mr. President, Your Honors, counsel opposite. For the defense today, myself, Courtney Griffiths, assisted by my learned friends, Mr. Morris Anya, Mr. Terry Manyard, and Councillor Superwood. Also our case manager, Salah Moyleman, and also we're joined by the acting principal defender, Ms. Claire.
Good morning. We'll take appearances first, please.
Appearing this morning for the prosecution, the prosecutor, Stephen Rapp, Mohammed A. Bangura, Christopher Santora, Maya Dimitrova, and myself, Brenda J. Hollis.
Yes, Mr.
Good morning, Mr. President, Your Honors, counsel opposite. For the defense today, myself, Courtney Griffiths, assisted by my learned friends, Mr. Morris Anya, Mr. Terry Manyard, and Councillor Superwood. Also our case manager, Salah Moyleman, and also we're joined by the acting principal defender, Ms. Claire Carlton Hansons.
Yes, Mr. Grievous, I believe you're going into evidence today.
Mr. President, yes. But I understood that we were awaiting a decision regarding an application I made yesterday.
Yes, we are. I was going to announce that later in the day, but...
Very well. Very well. So I call Mr. Taylor, the accused.
Please repeat after me. I solemnly declare
I solemnly declare
that I will speak the truth,
that I will speak the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
I'm sure I don't have to remind you, Mr. Taylor, because you've been observing these proceedings now for many months. But it's vitally important that you keep your voice up and that you speak slowly and clearly. Can you give the court your full name, please?
My name is Dr. Charles Ganke Taylor, the 21st President of the Republic of Liberia.
Now, Mr. Taylor, as you are aware, you are charged on an indictment containing 11 counts, which alleges that you are everything from a terrorist to a rapist. What do you say about that?
It is quite incredible that such descriptions of me would come about. Very, very, very unfortunate that the prosecution, because of disinformation, misinformation, lies, rumors, would associate me with such titles or descriptions. I am none of those, have never been, and will never be, whether they think so or not. I am a father of 14 children, grandchildren, with love for humanity, have fought all my life to do what I thought was right in the interest of justice and fair play. I resent that characterization of me. It is false, it is malicious, and I stop there.
Now help us. Why did you launch an invasion of Liberia in December 1989?
Liberia has a very long and what some may call a checkered history. The MPFL that launched the revolution that I led was the second NPFL, not the first. Following years of turmoil that I would say goes back to as far as 1955 or before, and maybe at some point in time we'll deal with what 1955 meant to Liberians. We had problems. The government of one of my predecessors, Samuel Kanyan Doe, had led a very violent campaign against citizens of the country, and I have no direct quarrels with him because maybe he may have had his own reasons. But citizens of Nimba were killed. The general that led the rising during that particular time, General Thomas Kpakio, was captured, killed in Monrovia, and cannibalized by then members of the Armed Forces of Liberia. Elections were held. They were stolen by Doe, and there was a reign of terror. And so we went in to bring about some order and restore democracy in Liberia.
Now help us, Mr. Taylor. During the course of the MPFL's campaign in Liberia, were atrocities committed?
I will be the first to admit that bad things did happen in Liberia during the operations of the MPFL, for several reasons. Let's not forget, we are dealing with a period of tribal problems. Doe had killed Nimbadians, Guios, and Manos, and Crowns were involved in the operations, assisted by some other groups. There was bad blood, the need for revenge on the part of certain groups. All of these things were going on. So when we launched this revolution to bring about stability in the country, yes, there were times when some individuals, because of their own selfish motives, engaged in certain actions. But what is very clear is that when we found out that atrocities have been committed, we acted. There are so many cases that have come in evidence before this court where the prosecution have said that they called the names of several generals that were executed. Yes, we did. They were tried before military tribunals using the military code of justice that officers on this side of the court know very well, the Uniform Code of Military Justice. And if individuals and citizens were murdered in cold blood, they were taken before military tribunal. They had a fair day in court, and if they were found guilty, and the punishment was whatever I, as the leader of the MPFL, approved, there was just no indiscriminate killing of people. But these terrible things happened, but we took action as we found out. Now, I don't claim that we knew everything that happened, but whatever happened that we got to find out, we acted upon.
Now, you call it a revolution, Mr. Taylor. Why?
Change. Liberia had a history of one party. The true Whig party in Liberia was all of our party. Whether you wanted to be a member of the party or not, you were just a true Whigger. That Whig is that old Southern style politics that the quote-unquote Americo-Liberian brought as the free slaves returned from the United States. And they had what they call the Whigs. And so the true Whig party in Liberia was the only party. And that continued throughout the Talbot administration. And when Doe came in, he continued. So the revolution was to bring about a full change, to bring about democracy, multi-party democracy, may I say, and the rule of law, which we no longer knew after the failed attempt of General Kpakio. Things got really out of hand.
Was that revolution informed by any particular ideology?
You know, when we get into ideology, I've tried not to become so ideologically attached to some of these different dogmas that you hear. But it was informed by one thing: a desire for democracy and the rule of law.
Now, moving on, Mr. Taylor, did you knowingly assist Fode Sanko and the RUF to invade Sierra Leone?
I, Charles Ganke Taylor, never, ever, at any time, knowingly assist Fode Sanko in the invasion of Sierra Leone.
Did you plan such an invasion with him?
I never, ever planned any invasion of that friendly country with Fode Sanko.
Did you have prior knowledge that such an invasion would take place?
Now, I may have to probably just seek some clarification. I was aware from Libya that a Sierra Leonean group, the Sierra Leonean Pan-African Revolutionary Movement, harbored the intent to carry on such operations in Sierra Leone at the time in Libya. And so that's what I say, I need some clarification. But as to the Fode Sanko operation, no.
Did you ever provide the RUF with military assistance?
I did not provide the RUF with any military assistance to invade Sierra Leone. However, between the periods of August 1991 throughout May of 1992, there was cooperation between the RUF and the NPFL following the invasion of Liberia by ULIMO that had been armed, trained, and sent in by the Mamo government. Now, I provided for the protection of the borders of Liberia, as was my duty and responsibility at the time. I provided small amounts of arms and ammunition, more ammunition than arms, to that particular group. And now let me be specific. Before this court, these judges have seen a letter produced by the prosecution of Fode Sanko writing me a letter complaining about small amounts of arms or ammunition. Yes, and I think he had a reason to complain because, in fact, I was struggling myself and probably his expectations were too high. But I did. Between that period in question, and it ended in May of 1992, after several of my men that were providing security on that border, and in fact, jointly fighting a common enemy, happening to be ULIMO, we withdrew our men and seized all, and I mean all, cooperation with the RUF.
Did you thereafter provide any military assistance to the RUF?
None whatsoever.
Were you thereafter aware of atrocities being committed in Sierra Leone?
Well, I put it this way. There's no one on this planet that would not have heard through international broadcasts or probably discussions about what was going on in Sierra Leone. I would be the first to say yes, we did hear of certain actions that were going on in Sierra Leone that were a little strange to us because those things did not occur in Liberia.
What things?
Well, we heard that people were getting killed, women were getting raped, and different things, and we couldn't understand it. I could not understand it because these are things that we did not tolerate in Liberia. And so for me, it was unacceptable. But then again, we had no way of verifying whether these were true because we did not have anyone in there to tell us. Because these days when you see reports on television, I'm seeing on television this morning that I ordered people to cannibalize people in Sierra Leone. And when you begin to look at the different slants in the news, well, you hear them, you cannot verify them, and it was not my duty to verify them, but I would say we did hear about those things in Sierra Leone.
And had you ordered the RUF or any other group in Sierra Leone to carry out such actions?
That would be virtually impossible because the actions that we took in Liberia, and those actions have been spelled out before this court. They've talked about, the prosecution has talked about several generals that were executed. Well, they were executed for murder under the Uniform Code of Military Justice. They were, in fact, they were executed for rape. And so, if we were taking these stringent measures in Liberia, even if one were to assume for the sake of argument that as the prosecution states that I had command and control of Sierra Leone, which is not the truth, realizing the fact that we were dealing stringently with rape and murder and harassment in Liberia, why would anyone believe or bring themselves so low to believe that what I was not permitting in Liberia, even if I had control in Sierra Leone, I would permit in Sierra Leone? It was inhumane, it was wrong. I would have never, even if during the period between August 1991 and May of 1992, if I, during that period, while we had corporations for my security in Liberia, and I may say selfishly for our security, because in fact we used the presence of the RUF for that. But if that was occurring during that period, I would have done everything to stop it. And in fact, probably the cooperation, and let me just move the probable, the cooperation between the RUF and the MPF, again, during that period, would have probably ended in a shorter period of time. I would have never, ever permitted such to continue if I had anything to do with it.
Specifically, Mr. Taylor, did you ever order the trademark atrocity of the Sierra Leonean conflict, amputations?
It's impossible for that to have ever been ordered by me. Let's look at the Liberian Civil War. There's been no evidence before these judges, regardless of all of the witnesses brought here, the little ones like the mothers of this world, the sick puppies like the mother of this world. You understand me? That would say that this was ever, a situation that could have happened. No, ever.
To your knowledge, did amputations take place in Liberia?
Never. That's the point I'm making. Amputations throughout the history of Liberia and in all of the evidence here, even though the prosecution has tried to drag the Liberian civil crisis in here through the back door, when the indictment is as of 1996, there's not one case before this court of amputations in Liberia. None whatsoever. It's not a phenomenon of Liberia. It is wrong. It never happened in Liberia. I would have never, ever accepted that in Liberia, and we would have never encouraged that in Sierra Leone.
Mr. Taylor, did you plan or order or otherwise participate in the invasion of Freetown on the 6th of January 1999?
Let's look at the period in question, 1999 January. I'm a member of the Committee of Five, trying to...
Explain what that is, please.
The Committee of Five, upon my election as President of Liberia, ECOWAS had been dealing with the Sierra Leonean problem, then under the Committee of Four. Upon being elected, jokingly, my colleagues in ECOWAS said to me, well, you know, listen, we have a problem continuing in Sierra Leone, and you are an old rebel, so you know how to deal with rebels, so why don't you, we're going to put you on this committee to see how much help you can be to us, because you know how to deal with rebels. I laughed and said, well, I'm no longer a rebel, so, but I will do whatever I can. They said, well, don't forget, you share borders with Sierra Leone, so we want to bring you on this committee. And so I was placed on the Committee of Five to help to bring peace to Sierra Leone.
I'm sorry you haven't answered my question, Mr. Taylor. So let me ask you again. Did you plan or order or in any other way participate in the invasion of Freetown on the 6th of January 1999?
Okay, I answered that question. I stopped there because your second question was, what was the Committee of Five? Well, working on that committee, my job, I was put on the front line to help to bring peace to Sierra Leone. There were discussions that started, so my entire period was spent between trying to fix war-torn Liberia that had gone through a terrible 7-year civil war, while at the same time helping my colleagues to bring peace to Sierra Leone. Now, within this period of time, one would have to be almost a Superman to be performing, trying to rebuild his country, his economy that is torn, and having to deal with being a part of planning and ordering some invasion of Freetown on the 6th of January 1999. In fact, upon hearing of that invasion at that particular time, I was outraged because we had been doing everything as of August 1998 in consultation with our colleagues in ECOWAS. We had commenced putting pressure on the RUF to come to the peace table. And so what I had done, I had closed the border as of August 1998 with Sierra Leone as a way of trying to put pressure on the RUF to, first of all, stop making ceasefire agreements and breaking it on the other hand. So it is impossible. In fact, it is just incredible that on the one hand, I'm trying to work with Liberia with all of my own difficulties, working with my colleagues, trying to bring peace, and at the same time, getting involved in trying to order, plan, or execute some action in Sierra Leone on January 6th. Impossible. It could not have happened. I had no knowledge of it and was outraged as were all of my colleagues in ECOWAS upon hearing of this terrible thing that happened. We could not understand it.
Help us. When and how did you hear about the Freetown invasion?
My National Security Advisor, on the morning of January 6th, as is done in Liberia almost every morning, one of the first individuals that I meet as a National Security Advisor that will come in with news reports and the so-called intelligence overnight. And this was revealed to me by the National Security Advisor. Unlike what some of the witnesses have come here and said about me being sitting before a television 24/7, that's virtually impossible. The work of a person is not sitting before television. That's what other people are there to do. My National Security Advisor advised me of it as of the morning of January 6th.
And who was your National Security Advisor?
John T. Richardson.
And help us. What was in fact going on in Liberia in January 1999?
In January of 1999, we were going through I was dealing with the United Nations in trying to get them to help Liberia in capacity building. There were discussions about movement of refugees and trying to get them returned, Liberian refugees in other parts of West Africa, West African refugees. I was very, very busy with government.
Now help us with this. What was your major preoccupation after you were elected president in 1997?
We had a 7-year civil war. The country was torn apart. Everything was destroyed. The roads were bad. In fact, some of the roads that I hear claims of in this court that we were supposed to be transporting arms and ammunition on, I don't know if these roads even existed. We had total decay. We had 7 years of civil war, lives torn apart. My principal preoccupation was, how do we begin to rebuild the war-torn country? How do we begin to bring families back together, mend fence and reconcile? I was engaged with trying to get international assistance to build the country. After the years of the former President Doe, where things had gone far down the drain, the economy was virtually wrecked. Add 7 years to that, Liberia had really gone back, I would say, a quarter of a century. We were, some argued, operating in the 1920s. And I was preoccupied with trying to make friends, encourage countries to come in, look at investments and other things. For example, let's look at one principal area that we were preoccupied with. One of the big issues being raised, as though people don't understand better, but I guess this is the way propaganda goes. Let's look at the timber industry. All of the equipment in the country had been destroyed during the war, had been picked apart, parts taken off. The time required to revitalize, for example, the timber industry took us about 2.5 years between trying to encourage people to return, giving them incentives to come back to the country. We were just preoccupied with Liberia, not talking about having added the whole Sierra Leone part of it, with my colleagues encouraging me. But in short, I was preoccupied with trying to get Liberia back to life. This was my preoccupation.
And how soon after you were elected president did you become a member of the Committee of Five?
Oh, almost immediately.
And why did you become a member?
Well, I felt that after my colleagues jokingly asked me to, in fact, forced me to join, I thought that I could be of some help, because I realized that unless peace returned to Sierra Leone, there was no way that Liberia could make it. Absolutely no way. There were still some 260,000 Sierra Leonean refugees in Liberia during the war, while there were also some maybe 50, 60,000 Liberians in Sierra Leone and Guinea. Now, when you look at that, you can see that it was extraordinarily important that everything was done to bring peace to Sierra Leone, because number one, yes, there were all these accusations. There are always accusations, and I'm sure these learned judges understand with that when presidents accuse presidents, sometimes they're trying to what they call draw smoke. For example, so many times I accused Tijen Kaba. He accused me. It didn't mean that it was factual. Okay, so you have this situation where you have all these movements, you have the refugees you're trying to bring in. So it was the situation where I felt that we were so intertwined that the international community, looking at these accusations, were denying me aid. We could not get aid. We could not get assistance. So they tied the life of Sierra Leone, and if I may say that figuratively speaking, they tied the life of Sierra Leone to the life of Liberia. So for me, it became a duty and a responsibility to help in whatever way that I could to help end this conflict in Sierra Leone, because unless it ended, Liberia would never move. That's why I got involved.
Did you want to remain president of Liberia?
Did I want to remain?
Yes.
Well, of course, I felt I could make a difference. Yes, I wanted to remain president of Liberia because I felt I could make a difference.
Now, in your capacity as a member of the Committee of Five, what was your main objective?
The first thing that they did was to put me on the front line. I would say really put me on the front line, and because we had a border, and then said to me, we really want you to get personally involved in whatever way you can and keep us informed through consultations to help to bring peace to Sierra Leone. So my objective at a particular time was to do just that, get involved, help them work, arm twist here and there wherever we could to bring about this peace that not just Sierra Leoneans needed, but Liberians needed.
Mr. Taylor, in your capacity as a member of the Committee of Five, did you have personal contact with Sambokari?
Yes, I did.
Why?
Being on the front line and being in charge of the Sierra Leonean issue, as my colleagues had asked me to, and by the way, let me just add for the judges, this is contained in resolutions of ECOWAS that will be presented to this court. Communiques on the approval of ECOWAS stating exactly what I'm saying, asking me to get personally involved on the front line in helping to resolve the issue in Sierra Leone.
Now, in your capacity as a member of the Committee of Five,
Mr. Griffiths, I don't think your witness answered the question. Why did he have personal contact? Veered off.
Yeah, okay. Well, my colleagues had asked me to have this personal contact because of my experience, they had said before, as quote-unquote the old rebel. So we had to maintain this contact because I was placed with that responsibility to make sure that we did. And so we established this contact and began the process of what you may want to call being really a mediator at the time. And so we made contact with Sam Bokari because at this particular time, Forty Sanko, remember, is in prison. But let me just add, that contact was not just solely my prerogative. As I was in contact with Sam Bokari, so were the other members of that committee. They could call him. In fact, I could speak to him. I kept them briefed, but they also could call him at any time they chose.
What year did you first make contact with Sam Bokari?
Our first real contact with Sam Bokari was in late 1997 to early 1998. I can't recall the exact month, but it was very close around this time, following the second heads of state meeting, which occurred in September. So I will put it to about the last quarter in 97 to the beginning of 98, when I ordered the general at the Lofa side of the border to contact Mr. Bokari and the RUF people to invite him to Liberia for discussions and to inform him what my role was and in whose behalf I was acting, which is ECOWAS.
What's the name of the general in Lofa?
Sadly, so there is also a mosquito in Liberia. The name is General Christopher Vamos, aka Mosquito, who knew Sam Bokari during the period that the RUF and the NPFL cooperated.
What was that surname again, please?
I beg your pardon?
What was the surname?
AKA Mosquito. But the
surname? Vermo?
No, Vambos. Vambos. I think it's Vambos. Vamos. Christopher Vamos.
Help us a little further in this respect, Mr. Taylor. Did you equally have contact with Issa Sisse?
No. Issa Sisse at that particular time, no. Sam Bokari was the leader of the RUF and we dealt with Sam Bokari.
Did you at any later stage have contact with Issa Sisse?
Yes.
How did that come about?
My first contact with Issa Sisse was in 2000, around about, I would say May, June of 2000 was my first contact. This was the period where Forty Sanko had been arrested for the second time in the infamous situation in Freetown. Sam Bokari is now in Liberia, and ECOWAS. We were all very, very, very disturbed by the issues in Sierra Leone at the time of the unfortunate arrest of United Nations peacekeepers. And so we, through hundreds of calls, and it looks so simple now where the other side have tried to claim that we had control, but it is very important that we understand that the arrest of those UN peacekeepers were not a very small issue at the time. It was virtually a global issue. Speaking figuratively, I can say there were phone calls coming into me from everyone, their mothers and their grandmothers, about these UN peacekeepers that had been caught in Sierra Leone. And so I got in contact with him after being asked to do everything that I could to help in their release. This was the first main contact with Issa Sisse.
And help us, at the time you made contact with him, was Issa Sisse formally the head of the RUF?
No, he had not formally become the head of the RUF. However, he was the most senior general in the RUF at the time.
And so how did it come about that he was the person you spoke to in the absence of Fode Sanko?
Well, Sam Bokari is not there, who took over after Fode Sanko, and our questions were asked, and we knew, don't forget, at the time in 1998 that we established the contact with Sam Bokari as leader of the RUF, we provided for the RUF a guest house in Monrovia, not a safe house, a guest house, not a safe house, a house that was provided for them, that served as an office, as a lodging place, and a place where every diplomat accredited near the capital of Monrovia went, saw them, consulted, and more specifically ECOWAS ambassadors. Okay, so we knew, because the RUF had personnel at that property, and so through communications we got to know that the main person that was operating in Sierra Leone after the arrest of Fode Sanko was Issa Sisse. So we then sought to contact him.
Was he happy to adopt the role of leader?
Well, I tell you, Issa was one, he's a very careful person. I say this because in answer to your question, subsequent to this meeting, when I convened a heads of state meeting in Monrovia, later on in July of 2000, to try, along with my colleagues, several presidents of West Africa, I convened a meeting to deal with the Sierra Leone problem. We then posed the issue of leadership to Issa Sisse. He was a little reluctant and did not really accept unless he told us he got the permission from Fode Sanko, where both Obasanjo and Alpha Konare, Obasanjo, the former president of Nigeria, and Alpha Konare, the former president of Mali that was chairman of ECOWAS, that left that meeting to go to Freetown to meet Tijen Kaba to get Fode Sanko's approval. So, if I may say, Your Honor, I think he was one of those reluctant leaders at the time.
Did you, Charles Taylor, appoint him as leader of the RUF?
No, I never did. Never could have. If anyone did, I would say ECOWAS did, because at that meeting in 2000, I just mentioned that I convened a heads of state meeting in Monrovia. At that meeting were the president of the Gambia, President Yaya A.J.J. Jammeh.
Can you help us with some spellings, please?
I think it's on the record. I wouldn't like to mislead the court. I think it's on the record, please. I think these are names. I would just ask for some help from the court. Present at that meeting also was the chairman of ECOWAS, President Alpha Konare. He attended that meeting. Also present at that meeting is the late president of Togo, Yatsegme Iyadema. Also present at that meeting was the former president of Nigeria, Obasanjo, was present. I convened this meeting to discuss with them this problem that they have placed in my lap about Sierra Leone. And the question came up, what do we do? Fode Sanko is imprisoned. The July 1999 peace accord is in trouble. There's no one to talk to. What do we do? So we met, and at that meeting, all of the heads of state present agreed that the probable thing to do was to ask Issa Sese to take over the leadership. Issa at that meeting said, well, I have to go and contact my people back behind me in Sierra Leone, but even more particularly, I need the approval of the leader of the RUF. And so Presidents Obasanjo and Konari flew to Freetown. T. Jennings Kaba brought Fode Sanko to them. The message was delivered to Sanko. He approved it. Obasanjo and Konari left, went to their respective countries. Issa Sese returned to his post. 2 weeks later, Obasanjo and Alpha Konari flew back to Liberia, and at the Rabas International Airport, Issa Sese was appointed leader of the RUF.
Mr. Taylor, did you ever deal in diamonds with the RUF in return for arms?
Never. There is not one human who believes in the truth can say that I, Charles Ganke Taylor, dealt with the RUF or anyone in the RUF taking diamonds for arms or taking diamonds for anything. None.
I'll ask you very directly, Mr. Taylor. Based on the evidence called by the prosecution, and I'm speaking louder because I'm told that my voice was very faint, were you regularly receiving mayonnaise jars full of diamonds from the RUF?
Never. Ever did I receive, whether it is mayonnaise or coffee or whatever jar, never receive any diamonds from the RUF. It's a lie. It's a diabolical lie. Never.
Why did you step down as president in 2003?
Following the burning of the arms in 1999, Liberia came under attack by a group calling itself LERD. LERD happened to have been armed and supported through Guinea by the United States government. I do not say this in speculation. My government confronted the United States government, accusing them of this allegation. They never denied it. In fact, the ambassador accredited of the United States near our capital confirmed that arms and ammunition had been given to, quote-unquote, the Guinean armed forces, and whatever they did with it, they could not account for it. Well, diplomatically, we know what that means. It simply means that, look, this is covert, and we'll do it. So they did. Now, when we
Take your time, Mr. Taylor.
During the war, as LERD approached Monrovia, it was a very sad thing that happened. Mortar shells launched by LERD, shrapnel from those shells were taken to the U.S. Embassy. They confirmed that the shrapnel were shrapnel from United States mortars. Now, these shells had dropped on an area that is considered a diplomatic compound of the United States Embassy in Monrovia called Greystone, where hundreds of Liberians had assembled for rescue. Several mortar shells fell on that compound, and there were scores of people killed. There were limbs thrown all over the place. The citizens on that compound took the bodies and took them at the gates of the U.S. Embassy and said to them, well, here is what you have done to our people. The United States government, strangely, and maybe for the first time, and I stand corrected, did not condemn the shelling of those civilians in Monrovia. During the war, citizens had retreated to Monrovia. So I would say there were maybe about 1 million people that had gathered in different parts of the city. And I must admit, we've always known America to be, under some circumstances, humane. There are other cases where they're not. But for the United States government not to condemn these people on their diplomatic compound convinced me that the United States, in their regime change policy, where George Bush had called upon me to leave, he said Taylor must leave. The United States had sent from Iraq at that time 5,000 U.S. Marines. The prosecution knows this. I think they should bring the information. They have a right to, they know this. 5,000 Marines were within eyesight of the presidency. I could stand on my back porch and look at this huge American flotilla right outside of the executive mansion door. Their failure to condemn these atrocities convinced me that they will go to any length and probably kill the whole country to get rid of Charles Taylor. I then decided, in the interest of peace and the love for my people, that I will leave. That's why I resigned, and I did not, as has been said, run away. I followed the constitutional process as enshrined in the Constitution of Liberia. The legislature was informed that as of 11 August, midday, I would turn over the affairs of office to my vice president. And so when he sat here and lied before these judges that it was just, Moses said blah, that it just happened, he didn't even know he lied. The legislature was written a letter. He is the president of the Senate. He was present in the Senate meeting. He presided over the Senate meeting when the letter was read 2 weeks before. Programs were prepared. Heads of states were invited. South Africa, Thabo Mbeki, was there. We had the president of Mozambique, Chissano, present. The president of Ghana, Kufuor, was present. These things don't just happen overnight. And then, boom, spur of a moment, somebody shows up.
But that's what Mr. Moses Blah told these judges.
Well, he lied to these judges. Diabolically, he lied. And we will prove it here. There are videos and films of Moses Blah, who is, I know Moses very well. He read a prepared speech. Now, one would have to be crazy to believe that he sat down during the program and wrote a prepared speech. Nonsense. He lied to these judges in so many other ways that we'll get into later.
And help us. Was there an agreement setting out the terms for your resignation?
Yes.
What was it?
I was attending a conference for peace in Accra.
When was that?
That was around, I stand corrected, that's about June, I want to believe, May, June of 2003, when this infamous indictment was unveiled. And I said to my colleagues that, look, the situation in Liberia is getting very, very tenuous right now. And I've just had enough of this. And I explained this very incident that I just explained to the judges about the shell that had fallen and how people were getting killed and shells were falling all over the city. And I told them that I would step down, and they had agreed. Now, as we walked out of the meeting, all of the heads of state to go to the conference hall, the news came out that the indictment had been, what you call it in legal terms, had been opened or whatever, unveiled. We returned to the hall because they knew that problems were about to come. We go back to the hall and they say, oh my God, what is this? I said, well, gentlemen, we do have a new problem. And they said to me, well, look, this is unacceptable. We are here for peace.
Who said that?
All of my colleagues, Thabo Mbeki, Kufuor, Obasanjo, Kaba, Tijeni was in that meeting.
And what did he say?
Well, he said, well, I can tell you, if I recall Tijani's own behavior, I want to believe Tijani knew. He did not react in any way. He kept quiet. But my colleague said, but this is unacceptable. We cannot do this. And I said, well, Mr. Taylor, our brother, what would you do? I said, well, I have to think about it. And they said, well, look, it is important that you carry out what you said you would do here with us. And if you do, we are going to move immediately to the United Nations and tell the United Nations that this is unacceptable and that this indictment should be squashed. They sat in that meeting and instructed...
Excuse me, Mr. Taylor.
Yes.
We have a message from the stenographer that you're talking a little too quickly for it to be recorded. So
Okay.
if you could just slow down a little.
I'll do that. At that meeting, it was decided that if I carried out what I had said I would do, everything would be done for this indictment to be squashed. They then instructed the president of Ghana,
Who was that?
John Kufuor, to invite the British and American ambassadors, because these were the two countries that had been pursuing this war against me of regime change, and we will get into that at some other point. So the British and American ambassadors were called and were told by both the chairman of the African Union,
Who was that?
President Thabo Mbeki at the time, and the chairman of ECOWAS, John Kufuor, that it was decided by the African Union and ECOWAS that if President Taylor stepped down, that this indictment would be squashed, and that this was a decision, and that ECOWAS and the African Union would pursue this. My understanding subsequent to that, it was pursued when Obasanjo told me during the period of the negotiations for my going to Nigeria, that in fact he had spoken to all permanent 5 members of the United Nations, and they had agreed that he famously, in fact in the statement said, I will not be harassed. That tape exists, where they had told him that they would not harass him upon my move to Nigeria. And that is what I understood at the time.
Mr. Griffiths, I'm sorry to interrupt. You did ask about 2 pages before the question, was there an agreement setting out the terms of your resignation?
That's
What was it? I'm not sure that there's a straight answer to that.
Well, Your
I
Honor,
can appreciate a
yes,
straight
Your
answer.
Honor, you are right. When we're dealing at the, just as maybe the judges and lawyers do, by agreement, there was nothing written. from a diplomatic standpoint, when heads of state meet and talk to other world leaders and they say, well, this is the case, I consider that an agreement. There was nothing written, but ECOWAS and the African Union had been told through Obasanjo that everything would be done to squash this. This is what I mean. There was no written document, but for me it was sufficient, and I think for even my colleagues it was sufficient.
And did you subsequently step down?
Yes, I did. On August 11, as I promised, I stepped down and left the country.
And thereafter, Mr. Taylor, the public suggestion is that you subsequently tried to escape from Nigeria.
Well, you know, when you are dealing with the level of power play that I saw during that particular period is amazing. In the first instance, I was not imprisoned in Nigeria, so I could not flee. I was a free man in Nigeria. I went to where I wanted to go. President Obasanjo and I met maybe once or twice every 3 months. And let me say here, Olusegun Obasanjo, the former president of Nigeria, who I must admit, I would still want to consider a friend if he chooses to come before the world and tell the truth. Obasanjo knew that I was traveling, where I was going to and when. And let me just explain further. Obasanjo had invited me at the airport in Abuja. He informed me that he was on his way to the United States to meet with George Bush. But throughout the 3 years in Nigeria, Obasanjo had constantly reminded me that Nigeria was under tremendous pressure to quote-unquote turn me over, and yet said he could not do that. He came under so much pressure that even there are documentary reports of even former Secretary of State Colin Powell even coming to Obasanjo's rescue saying, well, look, don't hold this man responsible. It was a deal. That's how Taylor got over there.
Who said that?
A former Secretary of State, Colin Powell, in defense of Obasanjo's actions. He met with me and told me that he was under tremendous pressure on many occasions, but that he was on his way to the United States, and he knew that he would come under additional pressure, but he would not yield to such pressures. And in fact, Obasanjo said to me that Kofi Annan had called him and warned him that he should expect pressure in Washington, D.C. And I said to him that I wanted to travel. Now, I'm sorry that we do not have a map here. I think for the judges to see this.
Maybe at a later stage.
Very good. Calabar, Cross River State, is approximately, I would say, under 50 miles from the Cameroonian border. Where I was stopped in an area of Nigeria, the northern part of Nigeria is about 1,000 miles from Calabar. Now, in an area called Maiduguri, I was en route. Obasanjo had said to me that he was on his way to the States and that I could go to where I wanted to go, and when he got back, he would, inform me and I could return. I was en route. Now, the news reports that came out said that Mr. Taylor was trying to escape to Cameroon. Now, for God's sake, anyone wanting to escape, if in fact he was being sought or he was imprisoned, neither of those applied to me. Why would I drive 1,000 miles from Calabar to the border with Chad and leave Cameroon 50 miles away. Now, one would have to be crazy to believe that. Obasanjo knew I was going to see an old friend, Idris Deby, in Chad. Idris and I had been friends from Burkina Faso days, before he launched his revolution. He's a personal friend of mine. I was being escorted by Nigerian Secret Service, Nigerian security police, driven by Nigerians in a 4-car convoy. Now, unless you judges and the world believes I am stupid, which I'm not, I could not have been escaping with Nigerian Secret Service, armed police, driven by them, traveling 1,000 miles. Now, why my dear friend told the world that I was escaping, I swear, maybe one day he will come and tell these judges and the world. Now, I do know he was under a lot of pressure. I do know this. I remember he said to me at the airport, look, maybe after this third term problem, I'll see what we can do. But he was under tremendous pressure. And he left. I get to the border, and I'm stopped. I am amazed. What do you mean I'm stopped? All of the Nigerian security get out. These border people say they are border security, and they are ordered to arrest me. I was arrested.
Can we come back to that in a moment? Just
Yes.
clarify something before we forget.
Yes.
What do you mean when you mention a third term?
At that time in Nigeria, and Obasanjo and I had spoken as friends several times about it. The Constitution of Nigeria gives 2 terms to the presidency. There was a discussion in Nigeria at the time where Obasanjo was trying to seek to probably in some shape or form amend the Constitution to seek a 3rd term, and there were a lot of dissension to that particular thing, and it was causing a lot of problems. So he said to me, "Well, I'll be back maybe after this 3rd term situation. I'll know what to do." And so this is what he mentioned to me.
However,
Mr. Griffiths, throughout Mr. Taylor's testimony, certain names have been mentioned of people. For instance, the last one I don't think is on the record. I could be wrong. But I think it was Idris Kebbi or
No,
Deby?
Deby, the present person of Chad, Idris.
All
I
right.
think it's Idris Deby.
All right, thank you. Well, Mr. Griffiths, for the sake of the record, if you could make sure that where possible, those names mentioned by Mr. Taylor are spelt for the record.
I will do, Mr. President. Yes. We're at the border now, Mr. Taylor.
I am stopped and told that I'm needed back in Calabar. For what? Say, well, we are arresting you to send you back. We have orders from Abuja. Well, I said, who's in Abuja? I said, the president is in Washington, D.C. So I said, well, these are our orders. I was arrested. Kept for several hours, not taken back to Calabar. I was treated like a real common criminal. The border security were extremely rude. I was handcuffed. The Nigerian Secret Service and other officials with me said nothing. What was said at a particular time, because I said, but you people are escorting me. Look at what's happening. I said, well, this is a different operation, and once we hear now there are orders from Abuja, we can do nothing about it. They arrested me, put me on a plane, and flew me to Monrovia. Not to Abuja, not to Calabar, directly to Monrovia. I arrived at the airport, and I am turned over to some United Nations security that fly me into Freetown.
Now, how old are you now, Mr. Taylor?
Let me say I've exhausted my 61st year.
Now tell me, In light of that experience, even though you're 61, if you were alone in a room with Obasanjo, what would you do to him?
We'll kill him, man.
You know, as I sit here, I am still perplexed. I can claim to understand all of the intrigues that happened to me. I guess I may want to describe maybe a sequence of events that will take place. I would probably want to find out from him, why in the hell did you do this? And maybe the next thing would probably be maybe 2 former presidents involved in a little tussle. Because I am damn angry of what Obasanjo did to me. He had, until now, I do not understand it.
Now, Mr. Taylor, are you guilty of these offenses on this indictment?
I am not guilty of all of these charges, not even a minute part of these charges. This whole case is a case of deceit, deception, lies, and quite frankly, I cannot understand how some of these people were brought to the point, and may I stand corrected on this, to tell some of the lies that I have heard sitting over there. Is, I guess, what you lawyers call incredulous. It's impossible. Whether I lived 100 years, it's impossible what I have heard here, where humans can come and in an organized fashion lie and lie and lie. I just don't understand it. There is no way. I am not guilty of any of these. Is this whole, as I go back into my mind and the records and the issues of the time, the period of we're just leaving the Cold War, and there's regime change in Iraq, there's regime change in Liberia. When you look at all of these nuances, and you look at the characterizations of heads of state, I am this mad, wild man. They demonize you and set you up that even if a common criminal walk off the street and maybe put a bullet in your head, it would mean that people should cheer. They get people to a point where, maybe for survival they lie. People have been threatened. I've got ministers, former ministers of my government, that wouldn't even take a phone call. Mr. President, we're scared. We've been told if we ever talk to you, we are finished. This is a house constructed on disinformation, misinformation, rumors, assumptions, conjecture. Whether, like I said, whether I live 100 years, this is the experience of a lifetime that no human.
Can I pause for a moment, Mr. President, and assist with some spellings? Idris Deby, IDRISS, separate word, DEBY. Alpha Conarin, ALPHA, separate word, KONARE, acute. John Kufuor, JOHN, separate word, KUFUOR. Joaquin Chisano, JOAQUIM CHISSANO. Thabo Mbeki, THABO, separate word, MBEKI. Olusegun Obasanjo, Olusegun Obasanjo, Gnasingbe Iadima, Gnasingbe acute, separate word EYAD acute MA. I think those are all the names mentioned so far.
Yeah, thank you, Mr. Griffiths.
May I?
Mr. Chris is Christopher Vamos, otherwise known as Mosquito.
The spelling of Christopher Varma that I'm familiar with is Christopher, the familiar spelling, Varma, VARMOH.
I was a little, may I just complete my answer?
Of course you can.
I was a little moved, yeah. People have brought themselves so low. Yeah, people have me eating human beings. Now, how can people just be so low to even think about such a thing of me? I mean, Charles Taylor is supposed to be with an orderly of one of my security personnel sitting down eating human beings. Charles Taylor is supposed to be out there like some little common street thug, involving himself in the acquiescence in rape and murder, when this very court has evidence before it of the so-called many executions that occurred. Well, those executions, again, were not executions of civilians. They were military people that knew they were officers that committed atrocities against the people. They were tried and killed. I mean, this whole case has been about, let's get Taylor. So it's impossible for me to be guilty of this thing. This is the whole construct. We will build up this thing on Taylor. We will destroy him. We will bring him down. Haven't they had their pound of flesh yet? I am not guilty of all of these charges.
I now want to go back, Mr. Taylor, and start right at the beginning. You told us at the outset that your name is Dakpana Dr. Charles Ganki Taylor. What does the Dakpana stand for?
Dakpana, I am still the most senior traditional chief in Liberia. Dakpana means chief. In the African setting, maybe for our learned colleagues on the other side that are Americans, they do not know that we have chiefs in Africa. And I am the most senior traditional chief. Dakpana is chief. That's the meaning of it. Of all of the tribes in Liberia, there is, unlike what they've thought about the Polo Society, there have been, and I hope we can deal with it here, there are traditional groups in Liberia all over the country. There are about 27 tribes. Dakpana is the chief. That means I am the national chief. Still, I hold that position, and I hold it until death. That's what Dakpana means.
Did the witness say, did you refer to the Poro groups as...
These are traditional groups. It's a traditional society.
And Dakpana is the chief?
Not of that Poro group, but of all other. There are so many social groups in Liberia. The Polo is one. You have the Mulling is another. You have the Bodios. There are so many traditional groups in Liberia, but all tribes in Liberia have chiefs. So I am the most senior chief in the Republic of Liberia today.
Now, what's your date of birth, Mr. Taylor?
January 28, 1948.
Griffiths, this is a bit of, but what does the doctorate refer to?
Very well.
I received 2 honorary doctorate degrees, one from the University of China and the other from the University of Liberia. These doctorate degrees are what you may term respect. It's a form of recognition. It is not an academic doctorate, as going through a master's and a PhD, but it is a degree of recognition. I guess similar to what our learned judge received a few days ago, or should receive, may I say.
Now, what does the Ganki stand for?
Ganke is my name. I am a member of the Gola tribe. Ganke, the expression Ganke, the interpretation of that is leader, one that is strong. Ganke, one that is strong.
Now, you've told us that your date of birth is the 28th of January 1948. Yes?
Yes.
What's the names of your parents?
My mother is the late Louise Yasazo Taylor.
And your father?
Father is Nielsen Philip Taylor, both deceased.
And Nielsen is spelled Neilsen.
That is correct.
And Louise, normal spelling, Yassa, Y-A-S-S-A, Zoe, Z-O-E, Taylor. Am I right?
That is correct.
And how many siblings do you have, Mr. Taylor?
A total of 10.
How many children in total did your parents have?
My mother had a total of 15 children. Some were lost along the way.
And where do you appear in the list of children?
I'm the third.
And help us. Do you have both brothers and sisters?
Yes, I do.
How many of each?
Presently alive, I have 4 brothers and 4 sisters still alive.
And where do they live?
They all live in Liberia.
Now, your father, Nielsen Philip Taylor, what did he initially do for a living?
My father was started off as a small-scale farmer, involved in the cultivation of cane sugar. We grew up with that cultivation before he moved on to something else.
And what was it that he moved on to?
He later on became a teacher.
And did he remain a school teacher?
No, later on, he his last area of work was he became a judge.
And firstly, where in Liberia did he work as a school teacher?
I'm going to have to take you back a little bit here, if you don't mind. My father was brought up by the Lutheran Overseas Mission to Liberia, and that's how the name Nielsen comes about. The Lutherans, they're basically situated in Europe, had missions in Liberia at the time. My father was trained by the Lutherans and sent somewhere around, I would say, 1943, 44, to an area of the country called Zozo in Lofa County.
And Zozo is spelled Z-O-R, separate word, Z-O-R.
As a school teacher, yes, that is correct.
And did he remain in Zozo?
No, he taught in Zozo for some time. Zozo, we're looking at a period where there were no roads in Liberia. He had to walk, I think it took him 10 days to walk from Monrovia to Zozo. The Lutherans were missionaries, and so they went into parts of the country that had not yet been inhabited by whatever. And so he stayed there for about a year or two, and then they brought him back to Millsburg. That's Millsburg. It's a small town just outside of Monrovia.
And you say that he later became a judge. Where in Liberia did he practice as a judge?
Gee, I don't know the different circuits. I think it's the First Circuit of Montserrat now at the Temple of Justice. I think it's the First Circuit Court in Monrovia.
Now, help us a little bit, please, about the background of your father.
My father is from what we call the Americo-Liberian stock. My grandmother migrated from the United States in the late 1890s as some of the free slaves that came into Sierra Leone and Liberia.
What was her name?
Her name was what's grandma's name? I'm talking. It kind of slipped me.
Well,
but the last name is Briswell. Okay, we can go on. It will come to me and I'll tell you.
Try Serena Ann.
Yeah, Serena Ann. She was Serena Ann Briswell. She had come as a little girl and grew up in Arthington. Now, since
where in the United States had she migrated?
They had come from the Atlanta, Georgia area from the south. During that particular time, there were so many blacks that left the United States to come to Sierra Leone and Liberia.
Now, that name Bracewell, does it have any significance in Liberia?
Oh yes, the Bracewell family is a very, very, very large family. In fact, they've always been involved in politics in Liberia.
So that's on your father's side. What about on your mother's side, Yasser Zorotela? What's her background?
Now, my mother is what you call an Aborigines Liberian. She is from the Gola tribe and did not, quote unquote, come to civilization until she was a very big girl. And let me explain what I mean by civilization. When you are in the interior and she couldn't speak English, couldn't read or write or anything, and she was brought down as a house worker for the Americo-Liberian family that was settled in Arthington at the time. So she was brought down as a girl to clean the house, and she was the house girl.
And in which household was she working?
She was working in the household of my grandmother, Serena Ann. And it was in that house that she learned to speak English, and that's where she grew up, in my grandmother's house.
So effectively, she was a domestic servant.
That is correct.
Did your mother attend school?
Very little. My mother managed to go to the 3rd grade. She did not go beyond that.
So how did the relationship between your mother and father come about?
Well, as the story is told us, my grandparents were very, very religious individuals. They were Baptists. And I remember I said that my father attended a Lutheran institution, but my parents were Baptists. And my mother was a very pretty lady. And as the story goes, some friskiness occurred in the house between them, and my mother was impregnated. But because my grandparents were very strict, during those days, if you impregnated someone, you had to get married. There was no two ways about it. There was a side of the family that objected to it. It was from what we were told. Now, you know, I was not born at the time, so I'm just talking history, what they told us.
Why did they object?
Well, because they felt that my mother, being a so-called native girl, could not get married into an Americo-Liberian family, and they objected. But my grandparents on the other side, against the rest of the family, said, well, if she was good enough for him to touch, she's good enough for him to marry. And they insisted, and they got married.
And how old was your father at the time?
My father was no more than 21, 22, and my mother, I would say about 17, 18.
Now, you mentioned that certain parts of the family objected to that union.
That's
Can you
correct.
help us with that? What was the state of relations back in the first half of the 20th century between Americo-Liberians and Aborigines?
One of the problems that we still have in Liberia today is the same problem that can go all the way back to the date you just mentioned. An opportunity was lost by the settlers that came from the United States to bond with the traditional people. I think that was a big mistake then as now. If you were an Americo-Liberian, you stopped, so to speak, with Americo-Liberians. If you were from the Aborigine group, you stuck with them. The opportunity for education, now, if you look at the age of my mother, she gets married at 18 and she's in the 3rd grade because she comes down when she's a big girl. She's already, what? A big girl. She had to learn to speak English and start school. So there was not this social integration at the time. It was a real big tussle. I mean, Aborigines, Liberians did not have an opportunity to go to school. They were just, in fact, it was called the interior. And as a result, that opportunity was lost. And quite sadly, it exists to a great extent in Liberia today. One of my predecessors tried very hard to work against it. I fought, and maybe we'll probably get to this. This is why I succeeded, because I am about the first president of Liberia that fell almost dead center, half Americo-Liberian and half Aborigine. So, I mean, I could fit in any camp. So that social problem existed at that particular time, and it still exists now.
Now, where did your parents, in which town did they get married?
They got married in Atherton. That's Arthington.
And where were you brought up?
I was brought up in the little town of Millsburg. That is on the record, Millsburg.
And where is Millsburg and Arthington? Where are they located?
They are on the outskirts of Monrovia on the St. Paul River.
In which county? In
Mansueto County, about 25 miles outside of the city.
And how do you spell Montserrat?
That's Montserrado.
Thank you. And help us. What's the population of Arthington at the time when you lived there?
I would say about 10,000.
And Millsburg?
About half of that, 5,000.
And help us, Mr. Taylor. What was the economic and social conditions in which you grew up? Tell us a bit about your background.
I came up in very humble background. As I just said to the court, my father was initially involved in the planting of cane sugar. And I'm not talking about any grand scale. I guess during those days, if you had about an acre of sugar cane, you were supposed to be a farmer. But we worked on the sugar cane farm, and I guess we couldn't plant cotton. They did cotton back in America. But sugar cane was what they had to do. And we learned how to use the what we call at that time the cutlass, but what you call a machete, how to clean. So I learned how to work with my hands.
And help us, did you have running water and electricity at home?
Running water and electricity? You're talking about something far-fetched. You were lucky to get a clean glass of water. No. In fact, let's go back to even the type of house that we live in. We lived in either mud houses. I was brought up in a mud house covered with something we call it tarpaulin. I don't know if they have tarpaulin. I don't know how to spell it. I don't know if the judges know what tarpaulin is. It's some roofing cover that's put over the houses. So when you live in that kind of house, running water? No, there was no running water. We went to the creek to draw our water. We took bath at the same creek. We did fishing in that creek. By fishing, we would go and build dams and build the water and catch whatever was there and set traps to catch fish. No, there was no light and running water. That's maybe a different word, not for us.
Did you wear shoes, for example?
No. I did not wear shoes until I was a big boy. I would say about 8, 9 years of age. I went to kindergarten school with my 10 toes on the ground. And I guess for those that may not know, you walk on your bare feet until the bottom of your feet, becomes so tough and the skin gets so tough that I don't even think a thorn. We almost could step on, glass bottles and not get cut. Literally, because of the hardness of the feet. No. I came up in some very, 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 very humble circumstances.
Now, you told us that your father, having started life as a farmer, later became a school teacher and then a judge. Did he qualify as a lawyer at any stage?
What the apprenticeship over, I think it took him about 2.5 years. You train, and then before you go to the court.
Now, where were you when your father was appointed a judge?
I, at that particular time, had traveled by that time to the United States to study.
Now, did you grow up with your parents, Mr. Taylor?
No, I did not.
Who did you grow up with?
I was brought up by my father's godmother. Now, for the judges, in our areas, every child that is born in the church, there is something like a second parent that is appointed to stand in place in case something happened to your biological parents. They became your godmother. So my father's godmother, who was an older lady, took me at a very early age.
How old were you?
Oh, I was first turned over to them about 8 months old, I'm told. I was about 8 months.
And what were their names?
Her name was Martha Ann McAfee.
M-A-R-T-H-A, and normal spelling, McAfee, M, C, capital A, F, W.
And she was from the settler population. In fact, the McAfee family. She had also come over from the United States as a young girl.
And was she married?
Yes.
And what was her husband's name?
His name was Charles Cisco. So she became Martha Ann McAfee Cisco.
Now, why were you turned over to them at such a young age?
I tell you what, from what I'm told, my father and my mother, they're still very young, and my grandmother and Martha Ann McAfee are very good friends. Like I'm saying, she's the godmother of my father. And so after I'm born, you know, the old people did this. She went and I'm told she saw me and said, "This baby I like, I want this baby. Give me this baby. I'll take care of him. You don't have to worry about it." People were not so, in our setting, and even right now in Liberia and other parts of Africa, people are not, you know, we don't have some of the problems in the West where people are afraid to trust your babies with people. So they waited until I had stopped being I'm told breastfeeding had stopped, and I was turned over to her. Now, we are not talking about long distances. Arlington and Millersburg are two joining small towns. From her house to my mother's house, I would say no more than maybe 20 to 30 minute walk. So we're not talking about taking me 200-300 miles away. So I mean, it was just like one big family. People just didn't take it to be anything so big.
And did you remain with Martha for all the time thereafter?
Yes, I stayed with her until her death. I was then just about to graduate. I was a big boy then, about 18. Upon her death, I had then qualified for teacher's training, and then went on my own. But I was with her until her death at age about 18.
So effectively then, from about 8 months old until aged 18, she brought you up?
That is correct, and to help you, counsel, I called her mother and called my mother's sister.
Now, at what age did you start school, Mr. Taylor?
Oh, at a very early age. I did the pre-education at home. So at about age 7, I went to school in the first grade. So most of my preschool years I was taught at home. Remember now, we're talking about an American-Liberian family. They're all educated. And so she really taught me at home. So I went to school not at the ABC, what we used to call it then, but I went at age 7, first grade.
And what was the name of the school?
I went to the Arthington Central School.
And how far was that school from where you lived?
Oh, I'll say it took us about 45 minutes to an hour from where I lived to the school. Every morning we had to walk and then walk back.
And so, what time did you have to get up in the morning in order to get to school?
Very early. I would say around 5 o'clock, because during those days we didn't have a clock, but we woke up to the crow of the rooster. For people that know the village life, these small towns, the rooster will crow just about the break of day, and once that rooster crowed, we knew it was time to get up. So I now can put it to about, I would say maybe 5:36 in the morning. Well, we had to get up very early on the chicken crow.
How long did you stay at Arthington Central School?
I was at the Arthington Central School up to grade 8.
So, how old would you have been then?
Oh, I was 7, 8. Trying to figure out. I went to Riggs about 13, 8 and 13, 5. I would say that took me about, 5, 6 years.
So, where did you move to? Which school?
I was pretty good, and I don't say this boastfully. And I got a scholarship from a business house in Liberia to study at a Baptist, a foreign missionary Baptist school called RICS. That's RICKS, RICS Institute. This was a school that had been built by the, I'm sure Prosecutor Rapp would know, the Southern Baptist Convention built that school in Liberia.
And you mentioned the scholarship. Who provided the scholarship?
That scholarship was provided by an outfit in Liberia called the Resignation Brothers Corporation. That's, I think it's RASM, I think NY. I stand corrected on that. Resignation.
RASAMANY.
Right, Resignation Brothers.
Brothers Corporation.
That is correct.
And who were they?
They were business people. They did large business in Liberia, one of the biggest corporations in the country.
Of what ethnic origin?
The Lebanese.
And how many people from Arthington received such a scholarship?
I was the only one.
How long did you remain at Rick's Institute?
I was at Rick's Institute for about 2 years.
And then?
Up to grade 10. And then the government of Liberia had a program in conjunction with Tuskegee Institute in Alabama, the United States. Tuskegee is a black school, college, or university in Alabama. They had a program with the government of Liberia to train teachers to go out in different parts of the country into the rural areas to teach. An examination was launched. I took the examination and passed and was accepted at the school. And that school was called the Kakata Rural Teachers Training Institute.
Pause there. Tuskegee spelling Tuskegee. Kakata Kakata. Rural, as in RURAL, Teachers Training Institute. How long did you remain there for?
The program was a 2-year program. I did the 2 years. It was structured in a way that, in addition to being trained as a teacher, you were also being qualified as a high school graduate at the same time, so you didn't have to lose what you left behind. So it took me 2 years in the joint program to complete it.
And upon completion of that course at the Kakata Rural Teachers Training Institute, what did you next do?
Following the graduation, I was initially assigned to Bummy County, Bummy Hills in Bummy County. Bummy Hills, I'm sure is on the record here, to teach at the junior high school in Bummy Hills.
Pause there. Now, at what level were you qualified to teach?
Up to the junior high level.
And in what year did you begin teaching?
My first, in 1967, I, as a very, very, very young man, entered the classroom in Bummy Hills.
And help us, what was the name of the school at which you were teaching in Bummy Hills?
It was called the Charles H. Dewey Junior High School.
D-E-W-E-Y.
That is correct.
And you told us that was in Bummy Hills.
That is correct.
Now, what kind of town was Bummy?
Bummy at that time was a mining town. They mined iron ore at Bummy.
Who mined iron ore at Bummy?
We had a consortium of American, Swedish groups that were doing iron ore, but mostly Americans from the Pittsburgh steel setup in Pennsylvania, United States.
What were they called?
That Pittsburgh group, they call it, I think it's Birmingham. I'm not too sure, but it was out of Pittsburgh. I don't. But that group.
Try Bethlehem.
It's the Bethlehem Steel Corporation out of Pittsburgh.
If it's not in dispute.
No, he knows Bethlehem Steel.
And this was iron ore mining, was it?
That is correct.
Now, your students, what kind of age bracket were they?
Quite older. I would say the students range anywhere from between 20, 25, 30. And let me just clarify this for the judges. This is a mining industrial town. People are working for the company. Some of these people in this area are of the same caliber of Aborigines, Nigerians that have not had an opportunity to go to school. So some of them start school very late, and they're working and they're living in this town. So you had people in junior high school that were by far older. I started teaching at the age of about 18, 19, and there were many in that class, 25, 30. But they were well behaved.
And help us, your students were of that age. How old were you?
18, 19.
And was that fact of any significance?
No, not really. We were taught that just like this courtroom is this is the palace of these judges. They control this room. The teacher is the king of his classroom. You either do what we say in the classroom, behave, or you don't have to be in there. It was as simple as that. So, I mean, we had no difficulties, and I'm saying that they were well behaved in that industrial town.
Now help us. How long did you remain there?
1 year.
And then?
My people in Arlington became a little jealous and said that,
Why?
well, why should one of their own, being so qualified and recognized, be sent to a different part of the country when they needed me to help at home? And so they made a lot of fuss, and the education department transferred me to Arlington in 1968.
And where to do what?
To teach at the Arlington Central, the school that I went to as a young boy, where I taught math and science courses.
And for how long did you stay there?
I was there for a year, until the end of that year.
I note the time, Mr. President, and although we're a couple of minutes earlier, that would be a convenient point.
Right, thank you, Mr. Griffiths. We'll take our usual morning adjournment now, and we'll resume at 12 o'clock.
All rise.
All right, guys. All right, guys. Let me say thank you once again for following. We're gonna take our break, like I said, on the dashboard there, for this segment of the trial. We'll continue tomorrow by the grace of God, by 2 and by 3 tomorrow of the trial. Then by 2, you will hear more about which organization, which individuals that actually put the MPFL together, and you will hear more about from Mr. Taylor with respect to where did they get the funding from, and some countries that were, even some African countries that were involved, in bringing the carnage onto our country. You won't believe it, and this is why we say, I think for me, to be frank, I find it expedient now that I think it's about time now that we try to tell the story to our children, because some of them were, especially for our kids that were born somewhere, maybe they were 10 years old when the war came. Also, today they are adults today. They didn't know what they took part in whatsoever. They didn't know how they became to be called Zocos today. We made them that way. What we brought onto them, onto the nation, that made them to be Zocos today. We came and we said we wanted to change them. We wanted to change their lives also. But today we instead dehumanize them. Today we're pushing them one side. We're saying we don't want them in our communities. They are in the ghettos and whatsoever. Have we forgotten? No. Somebody was the cause of this guy turning that way. Somebody was the cause for that pregnant woman's stomach to have been opened. Somebody was the cause for that building to have been brought down by bazooka or whatsoever it is. Somebody was the cause. Somebody directed it. Somebody aided it. Somebody abetted it. I'm talking about the war in Liberia. That when you were walking from one distance, from one point to another, you will see a body somewhere and you'll find the head somewhere else. Somebody was the cause. So that's why, for me on my platform, I don't give, this is a Justice Forum platform. Let me repeat it. Justice Forum platform. This platform is not here to hail any praises to any warlords. When you directed the war, when you took part in it, when you sat down, you calculated everything and you say, I am carrying this on the people, on my own people, and you came, you brought it to us. Honestly, you are not my friend. Yes, some of you come here, you want to hail praises to these people. These are not people to hail praises to. You know what is happening now in the country, right? Because nobody has been punished. That's why a whole container of money getting missing. What kind of country is this? We catch them, we say yes, somebody actually stole the money, and we let them go. They go and live somewhere else, and they live in better life than the very, very people that are supposed to be looked after. Nobody cares for them. Here today in the country, many parents now are complaining that they can't afford to send their child who's supposed to start a first grade class, because why? They can't able to raise the money to register them. All of these issues, they are not just today's thing. Somebody planted it. So when you come on my platform here and you want to hail praises to those warlords, I can't keep you here for long. I'll block you right away you go. By the grace of God, Samsonic, by the grace of God, we'll be here tomorrow a bit early by, well, let's say 11 o'clock Liberian time. That will be 12 midday here in the UK. We'll continue because the two versions will follow up, and you will follow the synopsis of the whole thing here. And when you sit down, you hear Mr. Taylor calling names, calling individuals, calling organizations. All of them are Liberians. How will three groups of Liberians go and organize themselves and say, we are carrying war on our people? Ego. The very people that are coming to take arms and ammunition from them. When these people want to change, you know what they do, right? They go and stand in the land to cast vote. And they say, when they say this government is not doing good, they will go and stand in the land, in a long queue, and go and cast their vote and change the government that way. I can't. I will never blame the Western world for giving all arms and ammunition. We went and requested for it. We went and pawned our mineral resources under it. We mortgaged our mineral resources. We went and told them, say, give me ammunition. When I take power, I will pay you back. You will come and you can bring in your company, and you'll be mining the diamond. Yeah, give me some guns. Give me some AK-47. When we take over, at the same time while we're fighting the war, you can be cutting the logs and getting your money back. That's what they did. That's what they told the people. That's what they told the people. They lied to you. That's why up to now we can't. It's going to take a long time to. We the masses to actually enjoy the fruit of our time in Liberia. Thank you so much. The time is up. Thank you, and thanks for listening. May God bless you, God bless our continent, Africa, and may God bless Liberia. May God help us. May God help us to bring these people to justice. The same way Sierra Leone are doing. God will help us. Mr. Taylor was in trial for any war. All the questions that his lawyer asking him are on Liberia. They're just trying to lay the basis, or they were just trying. Mr. Taylor already here in the UK serving 50-year sentence. His son Chucky Taylor 90 years. Mr. Tom Owoyu, the last time in America, also 30 years. Agnes Reeves Taylor, the trial is supposed to be by the grace of God by October. I will keep updating you because she is here in jail in the UK. We have another 2 in other European countries, including Belgium and Switzerland. I want to say thank you so much. God bless you. And I'll catch you tomorrow at 11 o'clock Liberian time, 12 midday. That will be here in the UK. God bless you. And God bless Mama Liberia. Bye-bye for now.